My
Yes.
lord, item number 18, respondent number 2, filed an affidavit, kindly allowed to bring the affidavit.
Affidavit drawing.
Requisition दिया.
May I please your lordship? Item number 65, lordship, hearing matter, last item of this court, lordship. This matter may come after vacation, lordship. I have taken consent from the other side. On 5th, lordship, 5th November.
No fixed date. Heard Miss
As Kanun Rule.
S. Kanungo, learned counsel for the respondent, who prays for an adjournment. She submits that she has informed the counsel for the appellant also regarding her prayer for adjournment. The prayer is allowed. Let this matter be listed in the first week of November on a date to be fixed by registry.
Keep privilege.
May please, lordship. One, my lord, earlier rejected by lordship, my lord. One AB, my lord. The patient, my lord, applicant is, my lord, suffering from paralysis, my lord. Kindly may be taken tomorrow, my lord.
No, listing you have to
My lord.
file before registry.
Which
And
one matter? my lord?
motion you have to mention before the senior bench.
My lord, is earlier rejected, my lord, by lordship, my lord. Second application,
When have you filed?
my lord, one, my lord, 110, my lord.
No, when have you filed the?
My lord, 1st October, my lord. I have filed on 1st October.
Okay.
My lord. And my lord, another prayer, my lord, supplementary 59, my lord. I will take fresh step, my lord. Pokso matter, my lord, 59. After vacation, my lord.
Heard Mr. S.H. Sikdar, learned counsel for the petitioner, who prays for some more time to take fresh steps for issuance of notice on respondent number 2/informant. The prayer is allowed. The petitioner shall take steps within 2 days from the date of this order. The notice is returnable on 25th of October. List this matter again on 25th of October.
Through officer in charge, my lord. To the officer in charge of concern.
That is as per the
Right.
notification.
My lord. Hello, post.
My lord, today's item number 63 and 64 of supplementary list. I filed 2 applications for amendment of pleadings, my lord. These are in bench section. This will be called and taken on board today.
63 and 64.
63 and 64.
What is your prayer?
2 applications have been filed by the appellant for amendment of pleadings. These are in the bench section now. So today this may be called and taken on board.
May I please, your lordship. Similar prayer for bringing on record an IA for stay vacation. We filed it on 23rd September
Which
in item number 36 also. Of the daily list.
item number 36?
36. sorry.
I to
Mention
You
them.
submit to
I'll
mention.
oblige.
May I please, your lordship? I beg to mention item number 26. The matter may be kindly adjourned for the day. I've taken consent from the other side.
Miss, what is your name?
S. Boro, on behalf of RB Bora.
Item number 26.
Yes, lordship.
26. RB Bora is not okay. Heard Miss S.
Her mother-in-law expired, lordship.
Heard Miss S. Bora, learned counsel for the learned counsel submitting on behalf of Miss RB Bora, learned counsel for the respondent, who prays for an adjournment on the ground that the English counsel is in bereavement. She has informed the learned counsel for the applicant regarding the prayer made by her. The prayer is allowed. Let this matter be listed
After
after
vacation.
puja vacation on a date to be fixed by registry.
May I please,
Lordship?
I beg to mention, I beg to mention item number 27 for adjournment of the day.
You have informed the other.
Actually, lordship, we have taken the justice survey. Lordship, we need some
Heard,
more.
what is your name?
A. Shah, on behalf of Mr. B.J. Mukherjee.
Heard Miss A. Saha, learned counsel for appearing on behalf of Mr. B.J. Mukherjee, who prays for an adjournment on the ground of personal difficulties. The prayer is allowed. Let this matter be listed after puja vacation.
Please, your lordship. Lordship, I am appearing on behalf of appellant side. Lordship, item number 22. Kindly fix this case tomorrow, my lord.
You have informed the other side.
No, my lord.
You informed them. We'll pass the orders when the matter is called.
May it please your lordship, that this matter actually under the Arboretus Land Control Act. And my learned friend, client, your lordship, that is the plaintiff, they filed this suit, your lordship, for eviction of the defendant, that is the petitioner, your lordship, on the ground of defaulter and bona fide requirement. And both the courts, your lordship, they found, though adversely, your lordship, and there is perversity also, your lordship, concurring finding that I am a defaulter and that suit premises is required bona fide for the family members of the
Defaulter as well as bona fide requirement, both.
lordship. Now, at this stage, your lordship, may I pray, your lordship, notice of motion may be issued, your my learned friend has appeared. Records may be called for. At this admission stage itself, on perusal of the records, if your lordship find that the findings are correct, then the matter can be disposed of also. And there may be scope for modification also, your lord,
Okay.
at this stage.
Heard Mr. S. Ali. You have any sub?
No.
Heard Mr. S. Ali, learned counsel for the petitioner. Also heard Mr. A. Sattar, appearing for all the respondents.
Yes, my lord.
All the respondents. This application under section 115 of the Code of Civil Procedure, 1908 has been filed by the petitioner impugning the judgment and decree dated 9/7/2024 passed by the Court of Learned Additional District Judge number 2, Kamrup Metro, Guwahati, in title appeal number 37/2022, whereby the appeal filed by the present petitioner was dismissed and the judgment and decree dated 18/3/2014 passed by the Court of Learned Civil Judge number 2, Kamrup Metro, in title suit number 173/2023 was upheld. Issue notice to the respondent. Since Mr. A. Sattar has appeared for all the respondent, no formal notice need to be issued. Let the records of the title appeal number 37/2022 as well as title suit would also be necessary.
That will be necessary, my
As-
lord, because
as
the
well
evidence
as-
is there.
Title suit number 173/2003 be called from the concerned courts. Let this matter be listed for admission hearing when we can fix.
After vacation.
After puja vacation on a date
Yes.
to be.
In the month of November, my lord, any date. Lordship, in the meantime, this decree may be stayed, your lordship, till the disposal of this.
We have not filed the execution proceeding as of date because 90 days was to expire.
There is no execution proceeding.
Yes.
pending.
But you will say,
Either-
your lordship,
either
that
file
we
or
not
print.
execute the decree.
No, why should I say
of
that?
this
Why
matter,
should I
your
say
lordship.
that?
I have nothing to say.
I
No,
am
if they file execution, you come before the court.
for this court, yes.
That's
We are
why-
only issuing notice.
That's why, your lordship, if execution of the
And on the
decree is stayed,
admission stage, my lord,
that
he has
is
already
your
said
lordship,
that
till
on
the
the
disposal
admission
of-
stage itself, it will be decided, because concurrent finding is there, my lord.
I'm giving a fixed date. You choose a fixed date. Choose a date.
Choose the date, choose the date. এই যে। আচ্ছা,
এখন দেখুন দেখি।
হয়।
Last the records, first records will be called for a receipt of the records. November, your lordship.
Let this case be listed in third week of November on a date to be fixed by registry.
Last week of December holidays. না ঠিক আছে। Oblige, your lordship. Right.
May I please, your lordship? Lordship, by this petition, I have challenged the order dated 15/6/24, by which the petition filed under section under order 1 rule 10 sub rule 2 by the insurance company was allowed by the learned tribunal.
Who was impleaded? Who was impleaded? For impleading or striking out?
Impleaded the owner, driver and insurer of the winger in which I was traveling as a passenger. I preferred a claim, your lordship. The winger, there was a collision between winger and a truck. I, being injured, I filed a claim before the learned tribunal, your lordship.
Where is the impugn order?
Impugn order is at page 10, 11. Certified copy is on the top.
You have not filed any objection before the.
I have stated in my application that I have orally objected. And your lordship turned to last annexure. Last annexure is 31/30.
Now, what is your ground of objecting? Why are you objecting?
Your lordship, in the instant case, I adduce evidence. The insurance company also adduce evidence. Evidence were closed. Argument was heard. Then the case was fixed for judgment. Again, it has been come to the stage of DW argument. Then the case is fixed, further refixed for judgment. On the date of judgment, the insurance company come up with this application.
So belated stage.
Belated state, and your lordship, for a moment, your lordship may look into the last annexure, the petition, the application that was filed by the insurance company. I have the certified copy with me.
No, but if it is necessary party. Annexure 31.
Page 31. Your lordship turn to page 32. This application ought to have been rejected straight away on the date of filing, because your lordship will see verification.
Yes.
Verification part, there is no signature of the authority. How this petition can be accepted by the, first of all, accepted by the tribunal? And your lordship,
Now, for what the case is fixed, what is
fixed
next?
for SR 29/10/24. From judgment, it has gone to SR. I have filed my claim. If supposing that necessary party is not added, I will lose my claim. I cannot be forced by the tribunal to add parties. Your lordship, and your lordship, there is another provision, your lordship, in Rule 13, Order 1, Rule 13. What does it say? Objection as to non-joinder or misjoinder. All objection on the grounds of non-joinder or misjoinder of parties shall be taken at the earliest possible opportunity and in all cases where the issues are settled at or before such settlement. It is a provision. It is inserted in Order 1, Rule 13 in the same order. And that petition is questionable, Your Lordship.
Heard Mr. D. Mondal, Learned Counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner. Who is the petitioner? The petitioner is the claimant.
Claimant, Your Lordship. I have specifically pleaded that the accident occurred due to
Okay. Okay.
negligent driving of the truck.
By the petitioner impugning the order dated 15/6/2024 passed by the Motor Accident Claims Tribunal, Valpara in MSC case number 241/2017, whereby the application filed by the respondent insurance company under Order 1, Rule 10, within bracket 2, read with Section 151 of the Code of Civil Procedure for impleading of a party was allowed. Stop. Issue notice to the respondents. The applicant, the petitioner shall take steps for issuance of notice upon the respondents by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable on 30 October 2020. No, returnable on 6th of November 2024.
Your Lordship, I have one prayer. I have prayed for an interim relief.
What is
So
the,
till next returnable date, Your Lordship, the proceeding may be stayed.
it is your proceeding, you will,
Already evidence is over, DW is over, argument is over. Twice the case has been fixed for judgment. Now at this stage, impleading,
till the, stop. In view of the averments made in the application and submissions made by learned counsel, the further proceeding of MSC case number 241/2017 shall remain stayed till the next returnable date. Whether records would be necessary, but
for deciding this application, this petition, I think record is not required. I have already obtained the certified copies of all the orders. And more or less, all the orders have been annexed.
okay, we are not calling for records. But whether it was signed or not, how will we verify it?
Which one, Your Lordship?
The
Certified copies I have, I can show you, Your Lordship. Right now, I have the certified copy.
okay. List accordingly.
Highly obliged.
May it please your Lordship. My lord, I am before your Lordship, against the order passed by the learned court below, my lord, order dated 11/10/2023, my lord.
Where is the impugn order?
Page 43. my lord. The relevant portion is at page 45.
What is the order?
My prayer for review of that order dated 11/7/2023, my lord, which is in page number 29, annexure 8.
What was that order?
So we made a, we apply, we filed a petition for reducing further evidence, my lord. Since the stage was closed, we paid for further evidence on the defendant side, my lord, but the same was rejected. So the disputed land, my lord, it belongs to the Department of Post, my lord, Government of India. So some official witness and documents needs to be produced before the court.
Now, on what ground you are challenging that order? Where that order is wrong?
My lord, page 45, my lord, second paragraph. From the above mentioned provisions of CBC, it is clear that an application for review of an order may be made on any of the following grounds: discovery of new and important matter or evidence, my lord. Yes, that we have, my lord, we have sufficient evidence to official documents that has to be placed before the court, my lord. And any other sufficient reason, my lord. The land was acquired by the government, it was handed over to the Department of Post, having sufficient documents. These, some of that documents are required to be placed before the, produced before the court, my lord.
You are the defendant.
Yeah, the defendant in that title, my lord. Union of India. So at this stage, my lord, if I am not allowed to produce those documents, my lord,
At what stage this suit is pending?
now, my lord, after that, commission report, hearing of commission report, the report of the circle officer and all. So those things, my lord, we are required to produce before the court.
When is the next date fixed?
Next date is on
Heard Mr. G. Pegu, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 11/10/2023 passed by the Court of Learned Civil Judge Joint Division number 1 Dhamaji in Ms. J case number 6/2023 arising out of title suit number 1/2019, whereby the application for review of the order dated 11/7/2023 passed by the present petitioner was rejected. Stop. Issue notice to the respondents. You are government advocate.
my lord, central government. Series.
Okay. Issue notice to the respondent and call for the case record of Ms. J case number 6/2023 arising out of title suit number 1/2019 from the concerned court. The petitioners shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 6th of November 2024. List accordingly.
My lord.
After some.
May I please your lordship? It is an application under 482 of the BNSS. Now, what has happened in this application, lordship?
Item numbers?
Lordship will kindly find the FIR that is figuring in page number 18, but the Azahar is in page number 20 to 22. Now, it's a long Azahar, I cut short it, lordship. What has happened? This Azahar is against one Santosh Kumar Chaudhary, against with the allegation of disproportionate asset, Lordship. Now, this FIR has been registered under 13(1).
Disproportionate assets.
Yes, Lordship will find in page number 21. They are saying the percentage of DA is 174.89. Lordship has an occasion to deal with this case. I'm coming, Lordship, slowly. Now, what has happened, Lordship will kindly see.
Who is the petitioner?
Petitioner is now the father of this FIR named accused. Petitioner is not named in the FIR, Lordship. Now, this petition has been registered under 13(1)B, AB, that is B, disproportionate asset. But 107 has not been added. There is no allegation.
Petitioner is the father.
Petitioner is the father of the FIR named accused Santosh Kumar Chaudhary, Lordship.
Father is apprehending arrest.
Yes. Now, why, Lordship will kindly see. They have issued a 41A notice, page number 43, against the father. Now, what has happened, Lordship will kindly see. During this development of investigation, the IO files an application before the learned special judge, Assam, stating inter alia that some documents in regard to this case is concealed in Bachwara, that is the native house of the accused named FIR and the house of the petitioner before Lordship. Now they went, make a search at Bachwara, they did not find anything. They did not find anything. Obviously, they will not
Where
find
they
anything.
went? Bachwara?
Bachwara is the
Where it
native
is?
house. It is in Bihar, Lordship.
Okay.
It is the native house of the petitioner. And it is also the native house of the FIR named accused. Now, what happened, Lordship will kindly see. The IO filed a petition before the learned special judge Assam, stating inter alia that some documents in regard to this case is concealed at Bachwara. So the special judge gives him a search warrant. He goes to Bachwara, conducts a search warrant, finds nothing. When he finds nothing, being annoyed, he issues this 41A notice. Absolutely nothing. Lordship will kindly see. Lordship has an occasion to deal with this. Lordship will kindly come to annexation number 4, where Lordship was pleased to give anticipatory bail to the FIR named accused. That
Where
is, the
FIR
Lordship.
named accused is on bail.
Yes, Lordship. Lordship has granted anticipatory bail. Page 48, Lordship will kindly find. And he has cooperated with the investigation. Most interesting part of this, Lordship, is that this is a case of disproportionate asset. The moment the FIR was registered, Lordship, and the accused was issued a notice under 41A, he appeared after getting bail from this honorable court, and he has already filed his assets and liabilities. Everything is there before the IO. There is nothing for the IO to summon now the father who is 74 years old. And Lordship, while this investigation was going on, the FIR named accused, he apprehended that the investigation was in fact not going in a proper manner, the way it should have gone to. So he filed a criminal petition before this honorable court. Lordship will kindly find annexation number 6, Lordship, page number 54.
Where
that
is where is the notice?
That is, Lordship will find annexation number 3, Lordship, is the notice served to the present petitioner before Lordship. That is
Then
page 43.
why are you apprehending arrest?
I am apprehending arrest, Lordship.
They
Kindly
have
see the
issued
chosen
notice.
date.
They have issued notice because they don't
Lordship, kindly
intend
see
to
the
arrest
chosen
you.
date. Kindly see the chosen date, 5/10/24. And from 6/10, it's going to be a vacation. I apprehend the moment I appear, I will be put under arrest because of no reason.
Why? Why?
No reason.
No, what is the,
There is no reason, Lordship.
no, what is the reason for your apprehension?
Yes, that is what I'm saying, Lordship. That they went to my house for a search. During search, they wanted to collect the land documents of my own house. I said a survey is going on, so I cannot give you the land documents. And being annoyed, he has issued this 41A notice, Lordship. Lordship, kindly see, the investigation is in the 6th month of the investigation. After 14 days, it is already a mandate of law that 41A notice cannot be issued. And then there is no 107 against me. There is no case that the parents of the accused named FIR is abating all this offense. There's no question of calling him now at this stage. Anyway, I want to appear, Lordship. I want to appear. I want to put my statement before the IO. I am praying for some protection to me. Considering my age, Lordship will kindly see. Medical documents I have already annexed.
Lordship, what is submitted, everything will be revealed from the case diary. But the 41A notice was issued. My lord, during investigations, my lord, it's revealed. My lord, probably my lord, his father
Then
is also my
107
lord.
ought to have been added.
Then
Without
my-
107 IPC, can they indulge into those investigation? This is really serious. How under
No,
13B,
let him appear. And,
I will appear, Lordship. I want some protection, Lordship.
okay,
I will appear on 5th itself.
heard Mr. A. Bhattacharya, learned counsel for the petitioner, also heard Mr. M. Fupan, learned public prosecutor, Assam. This application under section 482 of BNSS, 2023 has been filed by the petitioner, Shri Shiv Shankar Chaudhary, who is apprehending his arrest in connection with CM's vigilance. PS case number 4/2024 under section 13 within bracket 1 within bracket small b /13 within bracket 2 of the Prevention of Corruption Act, 1988. The gist of accusation. Where is the bail order of the co-accused?
Lordship will find a bail order annexure 4, page 44, Lordship. The pertinent part, Lordship will find in page 48. Therefore, for the reasons mentioned above, the petition is thereby directed to appear before the investigating officer within a week from the date of the order and cooperate with the investigation. If he does so, within a stipulated period, in the event of his arrest, this is.
Okay. The gist of accusation in this case is as follows. Quote A from page 45 of the application. Learned counsel for the petitioner has submitted that the named accused in this case, namely Santosh
Santosh
Kumar
Kumar Chaudhary.
Chaudhary, has already been granted anticipatory bail by this court by order dated 24/2024, passed in AB case number 1012/2024. Learned counsel for the petitioner has submitted that the present petitioner is the father of the named accused. And during the pendency of the investigation, the investigating officer also obtained a search warrant to search the residence of the present petitioner situated at Bachwara, Bihar, on the pretext that some documents relevant to the case have been concealed in the residence of the petitioner. However, it is submitted that nothing was found
Nothing was found.
from the possession of the
Connecting the FIR, Lordship.
present petitioner in connection with the alleged offense. Learned counsel for the petitioner has submitted that now, without adding section 107,
No, they have not added, Lordship.
without adding section,
Without adding.
adding section 107 of the
IPC.
IPC, the investigating officer has issued notice under section 41A of the CRPC to the present petitioner, directing him to appear before the investigating officer on 5th of October 2024. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate with the investigating officer. However, he apprehends that he may be arrested on his appearance, and as there would be vacations of court from 6th of October, he would be remediless in event of his arrest. Stop. On the other hand, learned public prosecutor has submitted that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing 25th of October.
25th, Lordship, I have some personal difficulty, Lordship. 25th, I will not be possible.
30
30 is okay.
30 of October as for the case diary. How, in the meanwhile, considering the fact that the named accused of this case has already been granted anticipatory bail, the present petitioner is directed to appear before the investigating officer on 5th of October 2024 and cooperate in the investigation. Stop. If he does so, in the event of his arrest in connection with CM's vigilance case, case number 4/2024, he shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Place this matter again on 30 of October 2020.
Much obliged.
May it please your lordship. The anticipatory bail application, the informant's daughter was married to the petitioner. But within 20 days of marriage, my lord, the informant's daughter was found hanging in the ceiling of the house. Now the informant lodges an FIR against me and my family members, alleging that I have committed murder. My brother and my father were arrested, and their bail application was considered by your lordship. And at that time, when the case diary was called for, case diary revealed that the cause of death was suicidal, my lord. And that has been our contention from the very inception, my lord, that this victim, my lord, she was in a relationship with another person. Her father forcibly married her with me. Subsequently, my lord, because she was unhappy and distressed with the marriage, she committed suicide. My lord will kindly have the bail order, my lord, page 18.
Yes.
Page 18, my lord. Paragraph 3 is the gist of the accusation, my lord, that on 29/6/2024, when Mokbul Islam lodged an FIR before the OC of North Mankachar Police Station alleging inter area.
Where is the observation regarding?
Observation, my lord, para 8, next page, my lord.
Yes, Mr. Das.
Lordship, since it is in the motion stage, Lordship, so his involvement may be different, Lordship. So in the FIR, it is stated that, Lordship, there is physical and mental torture is here, Lordship.
My lord will kindly note the date of marriage, my lord.
498A is also there. Lordship.
498 is it? 6/6/2024, and within 20 days of the marriage, my lord, she committed suicide.
Okay, we'll call for the case diary and
Lordship,
in the
immediately
meanwhile-
after vacation, Lordship.
Some protection will be
22nd.
accorded, my lord, because they have specifically accused us of murder, whereas the case diary on the last occasion made it very clear that.
Lordship, I have the objection on that ground that he is the husband, Lordship.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. A.K. Das, learned additional public prosecutor. This application under section 482 of BNSS, 2023, has been filed by the petitioner Akhirul Islam, who is apprehending his arrest in connection with Mankachar case number 142/2024 under section 498A/302/201/34 of the Indian Penal Code. The list of accusation in this case is quote para 3 from page 19. Learned counsel for the petitioner has submitted that petitioner is the husband of the deceased. And in the meanwhile, the father and brother of the present petitioners who were earlier arrested, have been granted bail by this court by order dated 12/9/2024, passed in bail application number 2411/2024. learned counsel for the petitioner has submitted that though the allegation against the petitioner and his family members is of committing murder of the victim woman. However, while considering the bail application of the co-accused, when the case diary was called for, an observation was made by this court after perusal of the case diary that the post-mortem examination report suggests that the death of the victim was due to asphyxia following ante-mortem hanging, which was suicidal in nature, and on that ground, bail was granted to the co-accused. The petitioner therefore prays that the allegations made against the present petitioner in the FIR is false, and he is ready to cooperate in the investigation. Stop. And hence prays for allowing him to go on bail in the event of his arrest. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of anticipatory bail to the petitioner on the ground that the present petitioner is the husband of the victim woman, and his involvement in the alleged offense may be of a different kind than that of the accused persons who are already released on bail, and therefore perusal of the case diary would be necessary. Hence, he prays for calling for the case diary. Stop. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing 30 October 2024 for the case diary. Stop. However, considering the fact that the materials on record, that is the observation made by this court in bail application number 2411/2024, which was made after perusal of the case diary, suggests that the death of the victim was due to asphyxia following ante-mortem hanging, which was suicidal in nature. Hence, the hence, considering the materials available, the petitioner is directed to appear before the investigating officer within 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Mankachar PS case number 142/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this matter be listed again on. He did this, 30/10 for his diary.
I'm deeply obliged. May it please. My lord, we have filed the application under order 39 rule 1 and 2. Now, as the lordships know that this is a case well, where we are saying that we are the co-owner and the respondent, my lord, they are co-owner, but then the stand is that the land has been bequeathed to them by one Jharna Majumdar, one
How
of the
much
legal.
is the area of the land
My lord, 1 kata.
and what stands over the,
My lord, this is the share will be 1/5.
no. What is there on the suit land?
Suit land, my lord,
It
they have
is it a
started
vacant?
taking advantage of the fact. They are saying that since there is a will in our favor, my lord, we are the owner. My lord, as your lordships know, until and unless it is probated, you cannot
No,
say
no,
that the
no,
right
no.
goes to you.
That is not my query.
My lord,
My query is, what stands over the suit land?
in the suit land.
Is it a vacant place or
No. The construction, they are making the construction.
already there is a construction?
Yes. And the trial court being satisfied that my lord, in similarly situated a case, Lord, I would like to take your lordship to
No,
that.
on that day, Mr. Datta mentioned, though he is yet to submit, that it is their residential house. Is it their?
No, it's not correct at all, my lord.
Okay.
My lord, they are saying,
But,
although-
but there is already a construction over the suit land.
my lord, earlier construction which was made by our grandfather, now that admittedly they have said they have broken it, they have demolished. And after that, they have started RCC construction. That is their stand, then since it is our land, we are making the construction. Now, admittedly, my lord, they are yet to be the owner of the land, because they are also the co-owner. Now, I will take your lordship to a judgment of the Madras High Court.
No,
In a-
before we go to Madras,
My lord,
can it be disposed of instead of?
yes, definitely, my lord. My prayer is simple, my lord. The construction should be stopped. That is what, my lord, Punjab,
No,
Madras,
who are the respondents?
the respondents,
Because in the event, if we go for IA,
my lord. Exactly, that's my worry, and on the last occasion also your lordship told me. But then only 1 and 2 possibly they are represented by Mr. Datta. Only number 3, I do not know whether he is representing them.
who is 3?
Srimati Uma Majumdar.
Whether 3 is also constructing,
They are there 1 and 2, but yes. They are all the co-owners. my lord. Now, whether Mr. Datta is on behalf of Uma Majumdar is also, my lord, I do not know, he can say it.
I'm on behalf of only respondent one, my lord.
In that case, my lord, what I suggest, subject to what your lordship says. My lord, your lordship can give a returnable date. On that date, if they appear, the entire matter can be disposed of, because his keeping it here is quite unnecessary.
yes.
Because till such time the construction should not be there. On the returnable date, the entire matter can be disposed of.
Yes, Mr. Datta.
My lord, in fact,
No, regarding his proposal, not on merit.
no, I am not saying so. They have made some incorrect and false statement that I would like to point it out to this honorable court. Number one, my lord, that
My
admittedly,
should be choosy about the words.
No,
Possibly a high court.
No.
why I am saying so, I will substantiate, my lord. The only 2 points I have to take a 5 minutes time, my lord. Now, so far the suit lane is,
before you start, because if in IA, if the IA is dismissed, if in case IA is dismissed, it would have an impact on your main CRP.
because
So,
the interim prayer means the allowing the main prayer, my lord. So what I propose, my lord, subject to the approval of this honorable court, because we need to file, they have not filed documents which are before the learned lower court. In fact, the honorable, the learned appellate court on perusal of the documents and pleading has passed the impugn order. So those documents are not on record. So what I propose, my lord, that the stopping of the construction would be prejudiced because of we are in possession and there is a prayer of mandatory injunction also.
Now, what I propose, issue notice both in the IA and the CRP, and the entire matter may be disposed of after the vacation, my lord, any fixed date. So that my proposal. If they press for any interim order, then I should, on the instruction, my client would submit before this honorable court.
Lord, your lordship has heard him. Now, the crux of the thing is this, he want the construction should be completed in the meantime. That's what I understand what you want to say. Now, my lord, in similarly situated cases, your lordship see, even the appeals court has said in such a case, status quo should be maintained. Now, if your lordship, just for a while, 84, my lord, SCC online Madras, my lord, entirely supports our case. I will read some of the paragraphs, my lord. My lord, paragraph 1 onwards. A small judgment, my lord. This appeal arises out of an order passed by so and so, refusing to grant injunction as prayed for by the appellants therein. The said CMA arose out of the order dated so and so passed by the trial court in so and so on the file of the subcourt Rishi Nagari, refusing to grant injunction pending disposal of the suit number so and so. The said CMA, the plaintiffs in OL number so and so, question the order of the trial court refusing to grant injunction, restraining the defendants therein from putting up construction in the suit property bearing survey number so and so, so and so. According to the plaintiff, the sixth defendant in the suit who is the respondent therein, though has purchased only 2/3 share in the suit, actually having his 2/3 share divided by metes and bounds. The trial court, however, refused to grant injunction on the ground that there is no prima facie case made out in so and so, and that appeal is still pending before this court. In that appeal, an interlocutory petition was filed for the grant of injunction pending the appeal. That petition was dismissed by Mohan by the following order, accepting to state that any construction put up by the respondent will be purely at his risk, for which he can claim no compensation whatever. I see no justification to grant injunction because admittedly the sixth defendant respondent has come to purchase the 8/12 or 2/3 share. This petition is dismissed. Then, my lord, the order of the learned judge proceeds on the basis that the respondent has come to purchase 2/3 share in the suit property, and therefore he can be permitted to put up construction at his risk on condition that he will not make any claim for compensation in future in the event of the plaintiff succeeding. The question is whether a co-sharer having 2/3 share in the suit property would be allowed to put up construction in the suit property even with such a condition as has been imposed by the learned judge. If the respondents claims to have acquired full title to the suit property, and if such a title comes to be questioned by other parties, it may be that the court prima facie proceed on the basis of his full title and permit him to put up constructions at his own risk and cost without any claim or for compensation. But where the respondent has not claimed full title to the suit property, the court cannot permit him to put up construction on the suit property, much to the prejudice of other co-sharers. If the respondent has acquired title to the property only partly, he cannot be taken to be the full owner and he cannot exercise rights of exclusive ownership to the detriment of other co-sharers. Unless he has his share demarcated in a suit for partition or by any other arrangement, he cannot put up constructions either on the entirety or on a portion of the property. On the finding given by the learned single judge that the respondent has purchased so and so in the suit property, we think that it is not possible to sustain the order permitting the petitioner to put up constructions on the suit property at his risk. The respondent being a co-sharer cannot be allowed
to cause prejudice to the other co-sharers by putting up a substantial construction during the pendency of a suit for partition filed by the co-sharers. In this view, we are not in a position to uphold the order under appeal on merits. Now, the last para 4, my lord. For the reasons stated above, the appeal is allowed and there will be an injunction restraining the respondent from proceeding with the construction on the suit site pending disposal of so and so. Now, my lord, in these sort of cases, what happens? It's a joint property. Now, after the construction is complete, there may be, my lord, third-party interest may be created. It may be put on rent. It may be the land and the building may be encumbered by taking loan. So these are the eventualities which comes. For that, why we are saying the multiplicity of litigation? Because we shall have to file a case to oust those people. There will have to be a file proper recovery suit or whatever it is. Now, just to, my lord, sustain all these things, it is required to, at this stage, it is better to be injuncted. Otherwise, all these problems will crop up and we shall land in trouble because there will be litigation after litigation. So obviously, your lordship will not like to happening of all these things. Therefore, if these can be arrested at this stage, it is better. Otherwise, your lordship can say, obviously, till date is a joint property. And there says that the one legal heir, that is Jharna Majumdar, she has bequeathed the land to them. Now, whatever, if you want to get the fruit of these, you will get it even supposing well it is probated. Now it will be tested in High Court to the Supreme Court level, which will go to another 25 years. And you do not know what is the result after all. So now to arrest all these eventualities, it is better to restrain, to stop these people to make further construction. And this is the case squarely covers our case. My lord, the Punjab and Haryana, in the similar line, my lord, I'll just read one paragraph. What is the position of the co-owner? The true question of law was referred by the Punjab and Haryana High Court. We are concerned in question number 2. Your lordship may see the last page, my lord.
Yes.
The last page, your lordship may see a prima facie case from there. A prima facie case is made out in favor of the plaintiff from the fact that plaintiff is original owner of the land to the extent of half share. On the other hand, the defendant has become a co-sharer by way of purchase by sale deeds of the year 2009-2010. The alleged CLU, etc., which have been taken from various departments will be of no help to the defendant. The same are without the consent of co-sharers. The land is yet to be partitioned by metes and bounds. A co-owner has a right to come to the court and get a relief if the acts of another co-owner are detrimental to his interest. So it can be said that every case has to be viewed from its own angle. In the present case, since the defendant prima facie committed those acts which are definitely detrimental to the interest of the plaintiff, therefore, the first appellate court rightly interfered in order to prevent the miscarriage of justice and for the advancement of cause of justice. This revision is against the order of reversal, but if the first appellate court has shown its maturity in allowing the application of the plaintiff under Order 39 Rule 1 and 2 by adopting the salutary and recognized principles of law, the High Court should not interfere in such type of discretion exercised by the first appellate court. As a result of the above discussion, it is held that a co-sharer, whether in exclusive position or not in exclusive position, cannot change the nature of agricultural land by raising construction detrimental to the interest of other co-sharer without seeking partition by metes and bounds. Hence, question number 2 is answered accordingly. Then in the similar way, my lord, the Apex Court also held in 2012 1 SCC, page 735. I'll take your lordships to.
No, these two are cases after hearing the parties.
My lord.
But now we are at the stage
Now
of
therefore, my lord,
paid interim injunction.
yeah, I'm asking for only interim period.
No,
They
but-
may be
but-
restrained.
But ad interim injunction, you must have a case that in the time when we issue notice, you will suffer irreparable loss. We are not-
Therefore,
May I indicating two facts, my lord?
No,
Because-
I'll come to you.
No,
I'm-
Lordship, Lordship,
I'm
I'm
to
sorry,
over-
I'm sorry.
have your nerve strong. My lord, now the question would be, my lord, who will be suffering irreparable loss? Obviously, we the people. Now, what they did in the meantime, my lord, thinking that they have become the owner of the land, they have the mutation is in their name.
Now, that is.
Now, can they do all these things, my lord? He's quite, my lord, managing all these revenue authorities. Otherwise, if it's a joint property, what right you have got to, my lord, mutate it is in your name. Only on the basis of will. And mutation will, my lord, as your lordship is aware, it will not decide the title until and unless you have substantive documents. So where is that document? You are saying that is
No,
a,
how will you suffer within these 15 days?
that's the thing, my lord. The construction is going on full swing. I have that instruction because they want to enjoy this period of the vacation because until and unless there is any interim order, the construction will go in full swing and they will complete the construction. And thereby, my lord, ultimately there will be multiplicity of the litigation in different ways. So these two decisions, of course, your lordship's query is that is after hearing both the
After
parties.
hearing by party.
Now, one of the parties is present here.
No. Only.
And my lord, in absence of, in every cases, when your lordship is persuaded that there is a prima facie case on behalf of the petitioner, invariably your lordship is passing interim order in the
No.
absence of other side.
No, not only on prima facie case. In case of injunction, you have to satisfy on all three essential ingredients.
Yes, that's the thing, my lord. So far prima facie case, both the court has accepted. So for the balance of convenience, obviously it is in our favor. The irreparable loss we shall suffer, my lord. Because if every construction is completed, therefore there may be the transfer of all these things. Now, if it is rented out, what will happen?
No,
I'll
those,
have to go for further litigation.
no, those are remote possibilities. Within 15 days, you are saying that they will construct, complete, rent.
I've constructed.
What used to happen, my lord, that is what I am, my lord, getting to your lordships. Now, generally this thing happens and just after 15 days, the entire matter will be heard. That also not possible
No,
because
we'll fix it.
that will be subject to, my lord, the service is complete in regard to 2 and 3. So that may not be possible. So interim order comes now, your lordship kindly see one thing. Within 15 days, they may not complete everything. Now for 15 days, if it is stayed, that also they are not going to be
No,
anyway.
but to grant you interim injunction when the appellate court has rejected it, first appellate court has rejected it,
My lord,
you must have a strong case.
that's the reason, my lord. Here, as your lordship has seen,
And in this case, as because the land is in their possession, they are the co-owner, they have names mutated in the records of rights. And the first appellate court has held that there is no irreparable loss. So you have to satisfy that you will
is there,
suffer.
my lord, well, my lord, I'll reply to that. Your lordship kindly see in my revision petition, Sanjay Kumar Majumdar, the power of attorney holder is Sanjeev Kumar Majumdar. He is given the power of attorney to Sanjay Kumar Majumdar. So 1 and 2 is the same. They are the main party. They are in possession of the land. And Uma Devi Majumdar is like us. We are not in position. She is also not in position. This 1 and 2, they are in possession of the land. is represented by Mr. Datta, my lord. So therefore, the main party is here.
Then we can dispose it of.
Yes, so that can be disposed of. My lord, the other day also I said, the entire matter can be disposed of. Let the trial court go into the matter. Till such time, my lord, there should not be any construction. That is my prayer in the right from the beginning, my lord.
But then why have you made Uma Majumdar a party?
Because in the suit, they are also party. Your lordship can see page 30 of IA, 30 of my IA.
In your IA, have you made out your case that dispensing pending issuance of notice to respondent number 2 and 3 ad interim?
One is the same, my lord, he is the power of attorney
No,
holder.
no,
One
my
is power.
query is different. In your IA, have you made out a case that pending issuance of notice on respondent number 2 and 3 ad interim injunction should be granted?
Just 1 minute. My lord, your lordship can kindly see page 30,
Page 30.
my lord, of our IA, my lord.
Yes.
Their statement, your lordship, it is WS, my lord. Page 30. That the answering defendants beg to state that after the demise of late Jharna Majumdar, said Sri Sanjay Kumar Majumdar, that is respondent number 1, became the absolute owner of the suit property. The answering defendants beg to state that Sanjay Kumar Majumdar, being the owner of the property, constructed a house on a portion of the suit premises for his residential purpose. Now, he is the main party, my lord. He has admitted in his written statement.
Okay.
So therefore, my lord, since they are claiming he is the, my lord, their statement is so clear, Sanjay Kumar became the absolute owner of the suit property. Now, when you are claiming you are the absolute owner and Mr. Datta is representing him, the entire case can be, my lord, disposed of. By observing that within a 2 or 3 months, the entire suit will be decided. Till such time, there should not be any further construction on the matter. And your lordship also see page 36. Page 36, that the answering defendants beg to state that on
before that, Mr. Datta,
my lord,
in your IA, where have you made out a case that ad interim injunction should be granted?
yes, that your lordship may see in our prayer
Which para?
at page 19 onwards, my lord. Page 20, my lord. Pending disposal of the page 20. Pending disposal of the civil division
No,
number
that
so
is
and
the
so.
prayer.
The lordship may be pleased to pass an ad interim injunction in favor of the petitioner by you have immediately restraining the opposite parties, there so and so, carrying out any further construction or any portion of the property. This is our interim prayer to restrain them to go for further construction. And there, the entire case is at page 36, your lordship will find answering defendants back to state that on 1/4/2024.
No. We are not on the main CRP.
My lord.
We are on limited question that whether to grant you ad interim injunction
Right.
pending service of notice on respondent number 2 and
Well-
3. And for that also you have to make out a case that your case is so urgent that dispensing the notice to 2 and 3, the relief should be granted to you. Otherwise, you will suffer
My lord,
this law.
so for 2 and 3, my lord, on the basis of the statement made in their written statement, my lord, we are, my lord, possibly we are thinking to struck them off 2 and 3.
Then do that.
Here, not there, my lord, here. Because it's represented by Mr. Datta on behalf of respondent number 1. He is the sole owner, that's the statement made. Therefore, my lord, even 2 and 3 is absent also, is not, they are not going to.
Then we can dispose it off. If 2 and 3 are not there, you have to take a decision. Because if 2 and 3 are there, notice are to have to go to them.
See, my lord, we are. My lord, your lordship, can I take your lordships to order 39? Rule 3, my lord.
Yes.
Rule 3, your lordship will find, before granting injunction, court to direct notice to opposite party. The court shall in all cases, except where it appears that the object of granting the injunction would be defeated by the delay before granting an injunction, direct notice of the applicant for the same to given to the opposite party. Provided that where it is proposed to grant an injunction without giving notice of the application to the opposite party, the court shall record the reasons for its opinion that the object of granting injunction will be defeated by delay and require the applicant. Now, these are the conditions.
Yes,
my lord.
that
Now,
was my
here,
query.
yes,
My query was in your interlocutory application, you have to mention reasons why the object of granting injunction would be defeated by delay. You have to mention the facts so
No.
that court can consider those facts and come to a finding.
my lord, the facts are very vivid.
You have not mentioned the facts.
No, that is the submission what I am making. My lord, as your lordships know, what will happen. Now, the construction, when the trial court passed an injunction order, they stopped all construction. The moment it was rejected by the appellate court, they started full swing. And till date, it is going in a multiplicity of, a multiple manner, well, the construction is going on.
No,
Now, these are the
that statement is not there.
statement, my lord, in so many words in the petition may not be there, but
That
your
has
lordship
to be
has
there.
seen in the injunction petition. That was our only plea. And it's a submission, my lord, these are the all legal submission. The inference can be drawn from the injunction petition, from the order passed by the trial court, order passed by the appellate court. And they are not denying that the construction is not going on.
Yes, Mr.
If the construction goes on, then ultimately everything will be over. And apart from all that, well, what right they have apart from the code? And in the meantime, what you have done? The mutation in which way? And on what basis?
Yes, Mr. Datta.
My lord.
Your, your submission is over.
Yes, more or less.
Yes, Mr. Datta.
My lord, I will take just five minutes time, my lord. Already Honorable Court has given a patience hearing
You
for
are
2
not
days.
striking out the names.
It's not possible because they are all the contesting parties
Yes,
in
my
this.
lord, I take responsibility of striking out 2 and 3. So far the revision petition is concerned.
You are making oral submissions.
Yes, yes.
Okay. Okay, yes, Mr. Datta.
May I, Lord, please. Now, so for this, I will start from this, my lord. Because in the injunction,
Because of the main revision petition. Mr. Datta. Instead of considering the IA, if you are striking out the names, we can dispose of the
Yes,
main
please.
revision petition. Yes, Mr.
Yes, my lord, please. My lord,
Can
There-
I take 1 minute?
Yes, sir.
Please. My lord, the lordship at page 15 of our IA.
Yes.
My lord, your lordship, this paragraph I am reading. Mutated in respect of the entire schedule ALN by at page 15, 1 5.
Yes.
Your lordship may read from the middle part, my lord, and who are presently from there. From bottom, 1, 2, 3, 4, 5, 6 line, my lord, from the bottom. And who are presently proceeding with the further construction on a war footing after the aforesaid interim injunction in Miss case number so and so has been satisfied with the court of the additional district judge Dibrugarh, while his judgment dated so and so per January. So these facts are already there. Will completely the construction of the scheduled property till the suit filed by the petitioner as a plaintiff being so and so presently pending before. So therefore, my lord, these facts are already there.
And page
Page 15 of my
of
IE.
I, okay.
This is our pleading, my lord. This is the part of paragraph 5.
Okay. Yes.
That's
my lord. My lord, I'm just indicating that factually, they are not placed all the materials facts before this honorable court. The construction is going on is not in matter in dispute. But so far the sharing of the land in question and the submissions were made that the entire property, the construction is going on is factually incorrect. The construction permission so far is concerned, my lord, it is only in respect of 118 square meter. That construction permission we were placed before the court below. That is 1270 square feet, equivalent to 8 luchas of land out of 20 luchas of land. Like, my lord, kindly have a peruse the photographs. These photographs we have placed before the learned law court. Lordship will find that in the first photograph, what happened, why we will start the construction. Because the old house in a rainy days is absolutely inundated in the floods water, in the rain water, my lord. And what you will find on the second photograph that the construction is going on, and the lordship will find that the old house is standing therein. Old house. Old house is standing therein still now. And in fact, we are living in the old house. And in the remaining land, we have constructed over only the 8 luchas of land, not over the entire land. Still the old house is there, and the old house is not demolished.
Okay.
Now, my second contention is, what is the share of this appellant? She having only 2 luchas of land. Because there are 5 co-sharers now, the living co-sharer, each having 1/5 share of 20th lucha. So each sharer having 4 lucha each. Now the father of this appellant, my lord, Utpal Majumdar, he has having two daughters. One is the appellant hearing and another Sanghamitra Majumdar. Now, Sanghamitra Majumdar has supported the case of the respondent number 1, my lord. That WS they have not annexed with this revision application. I just request my junior colleague to place it. So, you kindly have a look.
Yes.
That the WS filed by the sister of this appellant. That is, she is the one of the co-owner of the 1/5 share of the appellant. And she has, Lordship, can we have a look at paragraph 6 only, my lord. I have not take much time because paragraph 6, my lord. Lordship has got it. It's a WS by Sanghamitra.
Yes.
I'm just read out, my lord. So with reference to the such and such, the answering pro forma defendant state that the late Sudhanshu Bimal Majumdar is the grandfather, expired in the year 1960, and after his demise as per an oral family settlement, all other legal heirs relinquished their right over the property in favor of their mother, Parul Majumdar, and she became the sole owner of the suit property, and accordingly the entire suit land property had been mutated in favor of late Parul Majumdar on 17/12/1962, which was not challenged. By mutation or case number such and such. During her lifetime, Parul Majumdar sold the said suit land to her unmarried daughter, Jharna Majumdar, in the year 1972 by executing a registered sale deed number such and such, which was also not challenged in the suit. By virtue of the said sale deed, entire suit land had been mutated in the name of Jharna Majumdar by mutation case number in 1976, long ago, my lord. That after purchase of the suit premises, Jharna Majumdar became the sole owner of the suit property, that all other legal heirs knew about the above facts, but they never claimed any share and never disputed the same, nor raised any objection in respect of the suit premises. 7. That Jharna Majumdar during her lifetime executed a will on October 2014, which was duly notarized by the notary such and such, and Jharna Majumdar bequeathed the suit property to Sanjay Kumar Majumdar, that is the respondent number 1, my lord. And the then other surviving family members, namely Utpal Majumdar, that is the father of the appellant, Adhir Majumdar and Chidu Majumdar, knew about the execution of the will, but during their lifetime they never claimed any share and not disputed the will. That by virtue of the will, Sanjay Kumar Majumdar became the owner of the suit property. That is the stand taken by the own sister of the appellant.
But will is yet to be probated.
The legal stance, I cannot dispute this. Unless the probated, the will cannot be enforced. That's a legal, I cannot dispute it. But so far the share is concerned, my lord, absolutely the appellant hearing, even if she succeeds, she will get 288 square feet. That is the 2 lucha, because her own daughter, her own sister also does not support her case. 288 square feet. And there remains 12 luchas of land. Okay. So I am constructing only over the 8 luchas of land. Now, Uma Majumdar, she having 4 luchas of land, my lord. Uma Majumdar. She is one, the auntie, she is age about 70 years. So, and she also supported the case of the respondent number 1. So we, prima facie, we having the much more share than the appellant in question, appellant herein, my lord. Yeah. So therefore, the settled position of law is, if lordship is, I will take indulgence to place the judgment also. If the majority shareholder consented for construction, then one co-owner alone cannot raise any objection. And the fact remains, my lord, that even she succeeded in the partition suit, her share is intact. That is the 288 square feet. And my construction permission is only in relation to 1200 square feet, 1270 square feet. That is 8 luchas out of the 20 luchas.
And it's 2-storied.
at the old house. Old house is 2-story, but this is old, very, very, this is made up about 50, 55 years ago. So it is, condition is very deplorable, my lord. And if being the height of the building is, the road is above the height of the building. So the rainy days, it is not possible to reside therein. And therefore we decided, because since what we are residing therein, and Uma Majumdar, that is the auntie, one of the co-owner, she is also residing with us in the old house. And therefore, the learned appellate court came to a reasonable findings that the balance of convenience not tilted in favor of the appellant herein. And there would be no question of irrevocable loss because of the facts, my lord, that the share of the appellant is still existed even the partition suit is succeeded. Even his will is not probated. Even the stance legal position as on today, leaving aside my mutation, etc., my ownership, etc., keeping in mind that yes, this is a joint property, everybody having a 1/5 share, even that eventuality, my lord, my construction will not affect the share of the appellant here. And the statement is absolutely incorrect that the entire suit land we have made a construction. If that being so, my lord, the municipality corporation will come and demolish my structure because the permission is only in relation to 1270 square feet. Now, to not to prejudice the right of any of the parties, what I would like to submit before this honorable court, that we are undertake not to create any third-party interest. We will not create any third-party interest, rights, encumber or transfer any share of the suit property in any manner. And all the transaction undertaking in respect thereof shall be subject to the final decision in the court. Because two decisions I will place before this honorable court. The Supreme Court says, if a co-sharer has undertaken a substantially, the construction has been going on, then injunction would cause prejudice to the parties concerned. So in that case, my lord, what I undertake that on behalf, as instructed by my client, that we shall not create any third-party interest or encumber or transfer any share of the suit property in any manner, my lord. Now, may I take an indulgence to place two judgments of the Honorable Supreme Court in what I am submitted, my lord, that my submission will get support from this two judgment of the Honorable Supreme Court.
Yes.
And first I placed, my lord, the 2017 Supreme Court.
Yes.
Yes, ma'am. Just. Yes, ma'am. Lordship, can we have a look at paragraph 10?
Can I know the citation?
Yes, please. 2017 13 SCC 212. The defendant, para 10, my lord. The defendant opposed the application on several grounds. The trial court, by order dated such and such, rejected the application, which gives rise to the filing of the two miscellaneous appeals by the plaintiff before the High Court. It is a joint property, my lord. The High Court, by the impugned order, allowed the appeals and directed the parties to maintain status quo, which challenged before the Supreme Court, till final disposal of the suit. A further direction was given to the trial court to ensure final disposal of the suit within 9 months. Feeling aggrieved, defendant 6 is in appeal by special leave before this court. While issuing notice to this appeal to the respondents, this court on 8/6/2015 passed the following order. Heard such and such, issue notice such and such, learned counsel, as an interim measure. The Supreme Court has passed an order. As an interim measure, the effect and operation of the common impugned order dated such and such passed by the High Court of Rajasthan bench at Jaipur shall remain state. That's the status quo order was state. During the pendency of this petition, subject to the condition that the petitioner shall not transfer or create any third-party right in respect of the 30 flats proposed to be constructed on the property in question. Further, the trial court concerned is directed to decide the suit pending between the parties as expeditiously as possible. Now, conclusion is paragraph 17, my lord. As mentioned above, while issuing notice of these appeals to the respondent, this court has passed an interim order on 8/6/2015. We accordingly direct that the order dated 8/6/2015 would continue in remain operation, that is not creating third-party interest, my lord, till the suit are finally decided as directed. The construction was not stopped. Now in 2010 also, my lord, 2010, another judgment of the Supreme Court, 2010 2 SCC, page 77. I'm just pointing out the relevant part, madam. Para 9, what is subject matter of the matter, madam? Para 9, the appellant herein prayed for a decree of permanent injunction against the defendant not to deal with the property without a partition having been effected, and also paid for a mandatory injunction on the defendants to remove the wall which has been erected in the disputed property. Same prayer made by this appellant also. Now, Lordship, kindly have a look at paragraph 23. The learned counsel urged that as had been decided by this court in such and such, while considering an application for grant of injunction, the court has not only to take into consideration the basic elements regarding existence of prima facie case, balance of convenience and irreparable injury, it has also to take into consideration the conduct of the parties, madam. I'm stressing upon this. Conduct of the parties, since grant of injunction is an equitable relief. It was observed that such and such a person who had kept quiet for a long time and allowed another to deal with the property exclusively ordinarily would not be entitled to an order of injunction. Now, factually, my lord has taken note that in 1962, it goes to Parul, then it goes to Jharna in 1972. In 1976, the petition was granted. And since 2023, my lord, I have started construction. And since birth, I am in possession of the suit property. That is the old house. And this appellant has not come forward.
Regarding your possession over the suit property,
Is not disputed, my lord.
no, whether is there anything in the record from which?
No, record, because the lordship is also appreciate. No, lordship is appreciate that the mutation order itself shows that I am in possession. Without possession, no petition order can be granted, my lord. Because mutation, as your lordship is aware, is only granted on the basis of the possession or the title documents, my lord. And there is no dispute that I am not there. They have not disputed that I am not in possession, exclusive possession. And she never came before the court. Once I started construction, then he jumped in, and only her prayer is that to stop the construction. Now, lordship, kindly have a look in this judgment, paragraph 28. This 2010 judgment, 2010 judgment.
Okay,
Para 28.
yes.
Now, coming to the question of balance of convenience and inconvenience and irreparable loss and injury, which is important to consider in this appeal also. It has to be kept in mind that respondent number 10 has already acquired right in respect of the share of such and such. And in the event an interim order is passed preventing development of the portion of the property acquired by him, he would suffer irreparable loss and injury, since he would not able to utilize the property till the suit is disposed of, which could take several years at the original stage, and thereafter several more years at the appellate stage. The appellant herein has been sufficiently protected by the order of the High Court impugned in this appeal, while respondent number such and such permitted to carry out construction activities over the disputed land. He has been restrained from alienating or transferring the property or from creating any third party right therein during the pendency suit, which I also considered, my lord. My lord may direct in interim that no third party interest, which they also apprehend that I will rent out, I will dispose the my share also, my lord, which I am exclusively enjoying. So therefore, my lord, I'm just irrespective of that law, as lordship is aware, the limited scope of this honorable court under Article 227, the Supreme Court in a several judgment has said that unless there is a perverse finding of the court, lordship is, if I'm lordship permitted, I may place a judgment, recent judgment of 2022.
Yes, yes.
2022, lordship, the Supreme Court in paragraph 15 and 16 says the limited jurisdiction of this honorable court of Article 227.
Para?
Para 15, my lord. May I read, my lord?
Yes.
It is 2022 4 SCC 181. Having heard the learned
No. Citation is?
22 4 SCC 181, which is also endorsed by this coordinate bench of this honorable court recently, my lord. Paragraph 15, my lord.
Yes.
Having heard the counsel of the parties, we are clearly of the view that the impugned order is contrary to law and cannot sustain for several reasons, but primarily for deviation from the limited jurisdiction exercised by the High Court under Article 227 of the Constitution of India. The High Court exercising supervisory jurisdiction does not act as a court of first appeal to reappreciate, reweigh in evidence or for facts upon which the determination under challenge is based. Supervisory jurisdiction is not to correct every error of fact or even a legal flaw when the final finding is justified or can be supported. The High Court is not to substitute its own determined decision on facts and conclusion for that of the inferior court or tribunal. The jurisdiction exercised in the nature of the correctional jurisdiction to set right grave dereliction of duty or flagrant abuse, violation of fundamental principle law or justice. That they are failed to indicate that whether the fundamental dereliction of duty committed by the first appellate court. The power under Article 227 is exercised sparingly in appropriate cases like when there is no evidence at all to justify or the finding is so perverse that no reasonable person can possibly come to such a conclusion. And that is missing in this division application. They are only saying I am a co-owner to stop the construction. My right will be infringed. Irrespective of the fact, my lord, if the partition is allowed in favor of the applicant plaintiff, this appellant, then her share will be determined at the preliminary decree and then the final decree, and her possession will be delivered to her by the process of law. No person can prevent such a execution of the decree of a court, my lord. And that is only limited to 288 square feet, 2 luchas of land. And she come with a prayer to inject in entire 20 luchas of land. And her land, so far the her share is concerned, is absolutely there, and will not touch over that, my lord. And this is subject to the honorable court order. And secondly, which is most important, my lord, they have prayed for a mandatory injunction also for demolition. If the learned trial court, after reducing evidence, finds the merit of the submission on the basis of facts and law, that yes, the appellant has proved her case, proved her share, which I encroached, I transgressed, I captured, my lord, that will be removed by way of a decree of a court. Okay. Now, she will not come there, she residing separately. This is not her case that she residing there and her share we captured. It is not her case that she is urgently needed to come over the suit land and to make her accommodation there. This is not her case. Her only case is that I have a co-owner I would like to have a share. But in contrary, her own sister disputed the fact of this appellant, my lord, by filing. And she is alone. All co-owners are in a one group and she is alone. She is not supported by anybody because of her stance, which goes against the principle, the family decision of this Majumdar family.
Okay.
So therefore, I am what my prayer is that at this stage, no interim prayer is made out, my lord. In the IA also, they have not said anything. Any whisper is there.
No, Mr. Oh, they have prayed for striking out the name of respondent number 2 and 3. So we are
Then no, that will goes at the root of their revision application. And my humble submission, my lord, that would also a ground for dismissal of the entire revision application. Because in the revision application, the defendant number 2 and 3, who are the contesting parties in the injunction application, as well as in the suit, if they and in presence of them only the injunction application was considered by the learned lower court and also the appellate court. So if their name struck out, because they are also the co-owner of the property, as per their stand.
no,
as-
but
as
against them they are not seeking any relief.
My lord, only consider that any application in either interim or final, in a partition suit, all the co-owners are the necessary parties. This is the basic foundation of law, my lord, so far the partition suit is concerned. So all not only the 2 and 3, but all the co-owners are the necessary parties in any application before this honorable court or before the lower. If they are not chooses to make them a party, they are the necessary party. If they not chooses to make them a party in the proceeding, my lord, that will fatal for the case. And that will be decided by this honorable court, whether their presence is necessary or without their presence, a decision can be taken.
Okay.
In spite of the request made by the parties before this honorable court. That is my limited submission. So therefore, if the appellate court's order, my lord, is very justified and absolutely reasonable. There is no perversity in the order, which they are also not indicated, my lord. And so far, I am owner of the property or not, whether I am a co-owner or I am an absolute owner, that will be decided in the trial of the court, trial of the suit.
Okay. Heard, Mr. You have anything?
I have to reply. My lord, your lordship may see my revision petition at page 32. This is the appeal filed by other side. This is the judgment passed in the appeal, page 32 in the revision petition.
Yes.
This appeal is filed by Mr. Sanjay Kumar Majumdar all alone. And we have come against this. Apart from that, your lordship kindly see my learned friend has lectured that
I have not lectured.
please,
I do not know how Mr. Datta has
please
made
stop.
such a unethical, unprofessional
Your
remark.
lordship kindly
I
stop.
have seen, my lord. I am
Running
seen
commentary will go
from
on.
the
That is-
from the
He
first day, my lord.
doesn't have the
No,
culture
no, I
of
should raise my objection.
He hardly
I should.
practices here.
No.
Therefore, he doesn't have that culture.
No.
No. This is
Both-
another defamatory word.
From there only.
Both of you.
No.
There is
I
no
request the
When
learned
I
senior
start,
counsel.
Why he comes in between? Who
No,
is
no.
doing
He
right?
is
When
he
I am
has
on
made.
facts, he should keep his mouth shut.
No, you have.
He is a senior counsel. He should
Wait,
know, my
I
lord, how
don't
to
talk all
submit.
these things before the court.
I am very sorry, my
Why?
lord. I am a practicing in the district
See,
court.
my lord,
I admit.
can
I
tell one
admit.
thing only.
I'm a
Raising,
practicing
he
in the
should
district
not
court.
raise his voice. You raise your words. Because at the end of the day,
No, absolutely.
the
Very
rain
sorry.
throws
Very
flower,
sorry,
not
Mr.
thunder.
Datta. Very sorry.
Remember this.
Both our
The
surname
rain
become same,
the
my
rain
lord.
throws flower, not thunder.
No.
So keep
Our
your voice
surname,
down.
our surname are same.
Yes,
But
he
I'm
has
very,
surname, forget about surname.
I am very unfortunate that Miss Senior Counsel has submitted.
Is there,
It is
what
such
was there?
unethical,
He
unethical,
start that
unethical.
fact is there only, not
Yeah.
here.
It is
You have
not,
learned
it's,
many
Now,
things,
now,
you haven't
please,
done.
now please address to court.
No, my lord, I am very sorry. Why he should come in between? My lord,
if you say something unethical, I should say.
will you stop now at least?
No, you first
Will you-
withdraw
will you-
your, no,
My
no,
lord,
first
your
withdraw.
lordship will shut him, otherwise he will go on like that.
No, no,
He want to
don't,
disturb.
I'm
The
humbly my,
culture he has adopted, he cannot stop,
No, both,
unless your lordship asking.
both of you are senior advocates.
yes, correct, you know.
But then, can he come in between, my lord? That is my only worry. Because always he does, the last occasion he did that.
Please, no, you have to be careful not to use provocative words.
No, but then
You use the word
he starts
lecture,
that, he starts
therefore,
that, my lord.
therefore he got provoked. So both of you have to be careful.
He is saying all
Absolutely
surname is saying, so what? Why are you dependent on all this?
Now please address court.
Last time also he did the same thing. That's why I am reminding him. In this honorable court, we haven't learned all this foul thing. My lord, your lordship, kindly see the construction where he has made. Can he say? Is the land partition? Whether it is 1 inch or 100 feet, it doesn't matter. The land will have to be partitioned. You do not know where is your land. Then how can you make construction? That is the crux of the thing the appeals court many a times said. That every co-owner has right in every inch of the land. So unless it is partitioned, it is demarcated. My lord, you cannot make any construction. Because the end of the day, it comes that the middle part of the area is partitioned in my favor then. Therefore, my lord, we are saying there should be an injunction that their construction should be stopped. He is saying, I have some very meager amount of area there. But which is that area? Unless it is partition, can anybody say? He relied on 2017-13 SCC. My lord, subject to correction, I did not find from the bare perusal of the paragraphs that it is not relating to any construction. That was an agricultural land. 2010. My lord, 2010, my lord, I'll have to go through it. I just making a request to your lordship, kindly see the factual aspect of the matter. Whether it is related to any construction, and if the construction is there, it is at what stage? Because those are the things, my lord, it is required to be seen.
Okay.
And so far, parties are concerned, your lordship has seen.
Now, in this case, at what stage construction is there?
Construction, my lord,
In this
now
case.
my idea is, my lord, I have got the instruction. The wall is going on, my lord,
No, have you gone through the photographs?
photo, my lord, your lordship, we should not rely on the photos because what is happening there, it is difficult to say. But then instruction is that the construction is going on and the.
You give a copy of photographs, which you have.
And this photograph, my lord, we have filed in the trial court.
No, these are to be tested, my lord, by taking evidence from where it has come, whether it is of that particular site. There are so many discussions.
So your submission is this should not be taken into consideration.
This cannot be taken into consideration without, my lord, taking into evidence. And therefore, impleading of the party of these 2 and 3 is not necessary because we have filed our revision petition against this misappeal where they have only Sanjay Kumar Majumdar was the party.
Okay.
So, and your lordship has seen in 2003 Supreme Court, the lordship has said the earlier occasion I have, there are 25. No? Just you have with this. My lord, 2003 5 SCC 150. Last time I have given it to your lordship. Para 25. The law as to co-owners is well settled, where any property is held by several co-owners. Each co-owner has interest in every inch of the common property, but this interest is qualified
and limited by similar interest of the other co-owners. One co-owner cannot take exclusive possession of the property, nor commit an act of waste, ouster, or illegitimate use. And if he does so, he may be restrained by an injunction. A co-owner may, by an arrangement express or implied, with his other co-owners, possess and enjoy any property exclusively. Such a co-owner can also protect his possession against the other co-owners, and if he is dispossessed with the latter, he can recover exclusive possession. So therefore, every inch of the property, my lord, we have a share in it. So until and unless it is partitioned, properly demarcated, one cannot make any construction in that joint property. So here, my lord, where is the consent of giving, supposing, my lord, for argument's sake, not admitting that so all the co-owners have given him the permission. I do not know from where he's saying all that. These are to be tested. Now, supposing one co-owner has not given consent, can he make a construction? My lord, Appeals Court say is emphatic, no, you cannot do that unless you take consent of all the co-owners. That is the position of law, and the 2003 the judgment has made their position very clear. So therefore, the construction should not go on. My lord, your lordship, protect us by giving an restraining order for construction. And in the meantime, my lord, a time frame may be given so that the entire suit may be disposed of within a limited period of time.
Okay. Heard, Mr. Senior Counsel assisted by Mr. A. Bishwas, learned counsel for the petitioner.
My lord, may I just request one thing, my lord? I just, with the permission of this honorable court, just place two judgment. One is our High Court, 2024, and one is Madras High Court. Just 2024 SCC Online Guwahati 975 in relates to Article 227, my lord, and another in respect of the injunction of co-ownership property. That is in the Madras 1998 1 CTC 22, my lord. That I am requesting my junior to just place it. And so far the photograph is concerned, my lord, that is available in the records of the Landed Lower Court. We have placed it.
Item number
52, my lord, supply.
Also heard Mr. P. Datta. P. Datta, assisted by learned senior counsel, assisted by Mr.
J. Das.
J. Das, learned counsel for respondent number 1. Learned senior counsel for the petitioner submits that as the petitioner is seeking relief mainly against respondent number 1, and no relief is claimed against respondent number 2 and 3. Hence, he prays that the names of, no, before that, and as it was the respondent number 1 who had preferred the appeal before the first appellate court, which passed the impugn order. Hence, he prays that the names of respondent number 2 and 3 may be struck off, and this revision petition may be heard and disposed of, as respondent number 1 has already appeared. You are not pressing for IA. We are disposing it off.
Yes.
Learned senior counsel for the petitioner also submits that though an interlocutory application has been preferred by the petitioner, however, since main revision petition may be heard, he is not pressing for the interlocutory application as stop. On the prayer of learned counsel for the petitioner, learned senior counsel for the petitioner, the names of respondent number 2 and 3 are strike out from the revision petition, the registry to strike out the names from the cause title of the revision petition in pursuant to this order. Heard. Let this case be listed for delivery of orders tomorrow, that is on 4th of October 2024.
Much okay.
Grateful, grateful.
এসব সিজন করে দিন মায়ের নামই যাবে I'm taking a short break.
To a partition decree. What happened, my lord? I'm defendant number 6. I am a purchaser from a co-owner. Now, 2 of the co-owners have filed a suit for partition and their share of claiming their share of 2/3. Now, learned civil judge passed a decree on 21st of 12, 2023. And thereafter, the certain events and order has been passed, which being agreed by us, we prefer this revision application before this honorable court. What happened, my lord? On
No,
4th of,
against which order you are aggrieved?
I am aggrieved primarily on and from the order dated 4th of January 24. At
Which,
page 93, my lord. On the day of passing a decree, because it's a preliminary decree, and Lordship is aware that the preliminary decree, then thereafter the commission will be appointed, then after the commissioner report, then the final decree will be passed. Lordship, kindly have a look at page 93.
yes.
Lordship will find is a typed copy. 4/1/2024 decree prepared, sealed, signed, such and such. Now later on, the plaintiffs are directed to take steps as per the order dated such and such. That is the order of the judgment. The district collector Tingshukia shall furnish report within 5 months. Now nothing has been said. What's to be done, how to be done, and what is the manner to be done, which is required under Order 26, Rule 13. Which the commissioner has to submit a report. And thereafter only the final determination of the share to be looked into and a final decree to be drawn. And thereafter only the execution case has been filed. Now, very surprisingly, thereafter certain orders has been passed, which also we have challenged by this revision application. Lordship, kindly have a look at page 98. Lordship has got it. Page 98, madam.
Yes.
It's an order dated 19/7 to 24. Learned counsel for the decree holder such and present. Heard learned counsel for the decree holder on petition number such and such, praying to direct the district collector to effect the partition, which the district collector has no power to take legal action if any person obstruct the enforcement of the decree. Since the report of the additional deputy commissioner stating that the opposite party raised objections such and such, in view of the above, the petitions filed by the learned counsel for the decree allow issue precept along with the documents for effecting partition. Now, in fact, the district collector has been authorized to effect the partition before the final decree is to be drawn up. Now, the last order passed by the learned trial court, that is page 99. Plaintiff side is present through learned counsel, defendant side is absent without step. Now, just take a pause, my lord. Now, the defendants were never been informed about the proceeding enunciated by the learned trial court on and from 4th of January 24. No notice, nothing. Now, additional district commissioner has forwarded the report of the precept submitted by the circle officer such and such, seen the report of the circle officer Tingshuke Revenue Circle, wherein stated that the partition has been effected between the parties as per the order of this court. It is seen the matter is to be heard in presence of both the sides before passing order on the precept report. Precept report, this order is shown to the learners both the sides. Now fixed in today. Now, my first contention, my lord, that the since 4th January 24, everything has been happened behind the back of all the contesting parties. And the Lat Mandal, the circle officer, it was not by the district collector, not by the circle officer, but the Lat Mandal went to the Schedule A property.
No, but the matter is now fixed before the court, trial court. You can
No.
raise contention.
No, we will raise, but why we are before this honorable court? The entire exercise, because I am not challenging the order of the learned trial court in respect of 4th of January or thereafter. Because the entire, without preparation of a final decree, without a commissioner report, my lord, the exercise by the learned trial court is absolutely without jurisdiction. And therefore, we are before this honorable court. Because lordship is aware that order 18, rule 20, order 18, order 20, rule 18, my lord. Or kindly have a look at order 20, rule 18, my lord, first. Sub rule 2.
Just a minute.
Yes.
Order 20 rule.
Order 20, rule 18, sub rule 2, my lord.
Yes.
If and so far as such decree relates to any other movable property, the court may, if the partition of the separation cannot be conveniently made, because the preliminary decree has been drawn up, so therefore the court has in view that not conveniently made, without further inquiry, pass a preliminary decree declaring the rights of the several parties interested in the property and giving such further direction as may be required. So therefore, in the court, the learned court below has passed a preliminary decree only. The lordship only comes to order 26, rule 13. How the partition could be effected?
Order 26 rule 30.
No, 1-3, my lord.
Yes.
Yes, my lord.
Yes.
Yes. In our case, preliminary decree has been drawn up. Where a preliminary decree for partition has been passed, the court may, in any case not provided or by section 54, issue a commission to such a person as it thinks fit to make the partition or separation according to rights as declared in such a decree. Now the procedure has been prescribed. The commissioner shall, after such inquiry, as may be necessary, divided the property as many as shares as may be directed by the order under which the commission was issued, and shall allot such share to the parties, and may, if authorized thereto by the said order, award sum to be paid for the purpose of equalizing. This is not our case. 2. The commissioner shall, this is important, the commissioner shall then prepare and sign a report, or the commissioners such and such shall prepare and sign separate reports appointing the share of each party, distinguishing each share by metes and bounds. Such reports or reports shall be annexed to the commission and transmitted to the court. In the court, after hearing any objection such and such, the parties may make to the report or report shall confirm, vary or set aside the same. That commissioner report was not presented. The Lat Mandal went to the spot using the truck and etc., uprooted the tea plantation, make a 20 feet road, my lord. Lordship will find in paragraph 12 of our revision application, we have stated the facts. And so for the defendant number 6 is concerned, a part of the property I am dispossessed. the boundary fencing was removed. And surprisingly, no report has been submitted to the court. We have just got copy of the report, my lord. I asked request my junior to submit before this honorable court. They just received this.
Now, what is this report which is mentioned in order dated 18/9/2024?
18/19/24 says that the partition has been effected by the circle officer, my lord, who is not authorized at all. And in fact, the circle officer not affected the partition. The Lat Mandal of the area, he affected the partition. It is absolutely without jurisdiction. It is violates all judicial discipline, my lord. Lordship, kindly have a look at the report, please. This additional district commissioner forwarded the report of the circle officer. This is in vernacular, my lord.
Yes.
In vernacular says that such and such আদালতৰ আদেশখনৰ বাদী আৰু বিবাদীৰ মাজত বাটোৱাৰা কৰা হ'ল. Now it is not done by the circle officer. Lordship will kindly just on the next page, Lordship will find there is a report by the Lat Mandal. And he said, the Lat Mandal said that as per the order of the court, he make the partition.
Okay.
It is not signed by the circle officer, not signed by the district collector or any authorized person, my lord. Section 54 says it has to be done by the collector or gazetted officer deputed by him. So this is not a commissioner report, my lord. So absolutely, and Lordship will kindly take a note that it is not an execution proceeding. The learned trial court, without drawing up a final decree, sitting as an executing court, and allowed the unauthorized person to effect the partition. And thereby, such an illegal course of action disposes my land, my lord. And therefore, we are before this honorable court. Absolutely perverse, the entire action, they absolutely without jurisdiction. I may place a judgment of the Honorable Supreme Court. Lordship will find what the Supreme Court says about the preliminary decree and final decree, and when the decree is to be executed.
Now,
The
in interim, what you are seeking?
I am seeking, my lord, to stay the entire operation, this further proceeding of this matter, and also a status quo to be maintained, my lord, because otherwise they may change the nature and character of the entire land, and absolutely without jurisdiction. The Supreme Court says that only the final decree can be executed. May I place a judgment, my lord?
No. Before that, what?
Lordship, kindly have kindly look at my pair. At page 16, my. Till returnable date, your lordship, kindly the subject matter of the suit may be preserved.
Schedule LN.
Schedule LN.
Heard Mr. P. Dr. Learned Counsel for the Learned Senior Counsel for the petitioner, assisted by Mr.
J. Das.
J. Das, Learned Counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, impugning the order dated 4/1/2024 and subsequent orders passed by the Court of Learned Civil Justice Senior Division Tinsukia in title suit number 33/2012, whereby the District Collector Tinsukia was directed to effect partition of the suit land Learned Counsel for the petitioner has submitted that by order dated 4/4/2024, the the Court of Learned Civil Justice Senior Division directed the district collector,
4-1, my lord, 4-1.
yes, 4/1/2024, directed
Grateful, my lord.
district collector to furnish report without mentioning therein as to with regard to what matter the report has to be furnished. The Learned Counsel for the petitioner has submitted that in this case, the mandate of Order 26, Rule 14 in bracket 2 has not been followed, and the partition has been effected without issuing a final decree in respect of the suit land. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice to the respondents by registered post with ID as well as by usual mode within 7 days from the date of this order, returnable on 8th of November 2024. Stop. In the meanwhile, considering the submissions made by Learned Counsel for the petitioner, as well as considering the averments made in the revision petition, it is directed that till the next returnable date, status quo shall be maintained in respect of the Schedule A land. Schedule A land.
Schedule A land, it is the
Schedule A land. Stop.
Schedule A land of the suit of title suit number 33.
As mentioned in the plaint or in the title suit number 33/2012, list accordingly.
Grateful, my lord. Grateful.
In this case, I will led by Senior Counsel Mr. K. M. Chaudhary. Can it be taken up after some time?
Okay.
But can it be adjourned for the time being, Lordship?
Okay.
It says.
Your Lordship, latest status report was called for, not received, Lordship.
No, item 15 is whether service of report
Sir,
on
We have also not,
service is complete
we have not received, Lordship.
on respondent number 2.
There is a reshuffle, Lordship, in the office, so it is.
Okay. Heard Mr. A.K. Sharma. What's your name?
T. Colita.
D. Kolita, Learned Counsel for the petitioner. Also heard Mr. K.K. Das, Learned Additional Public Prosecutor, who prays for some more time for taking necessary instructions from the concerned or from the officer in charge of concerned police station regarding service of notice on respondent number 2. The prayer is allowed. Let this matter be listed again when
21st October.
on 25th of October.
Item 16.
What is this?
Service report received, Lordship.
Is there?
Yes, there is not, sorry, scan copy, Lordship.
What is the case?
My lord, the FIR is, your lordship, is 9, my lord. I'm a petitioner is behind the bar, my lord.
Whether the victim has been examined? Victim has been examined.
Probably, my lord, in the, because charge sheet was filed, my lord. Yes, yes, my lord.
Charge sheet frame, fine, Lordship, 1/8/2024,
No,
search
whether-
frame,
Whether,
search
vi-
frame, Lordship.
whether victim has been examined.
Victim, Lordship, it is not there.
Let the victim be examined.
Not a,
14/8 is for evidence, Lordship, fixed for evidence, so latest charge report.
No, you have to inform as to whether the victim has been examined or not. Because unless victim is examined,
my lord.
Sir, in this 16, no? Item number 16, victim is examined, Lordship. Informant is also examined,
okay. What they have stated?
implicated, Lordship.
Who? How many witnesses have been examined?
There are 8 witnesses, Lordship. 2 has been examined, informant and this one, Lordship, the victim. Service completed, Lordship.
Since when you are behind the bars?
2/5/2024, my lord.
How many days?
And that as on today, my lord, 152 days, my lord.
No, humble submission, Lordship, I want to state that this is a POXO case, so it need to be heard, Lordship. Informant,
For informant?
Lordship. Amicus curiae may be appointed, Lordship.
My lord,
POXO case, Lordship.
Notice is served on the
It is served, Lordship.
heard, Mr. What is your name? S. Hawk, learned counsel for the petitioner. Also heard Mr. K. Das, learned counsel for the learned additional public prosecutor, who submits that the notices issued to respondent number 2 to the officer in charge of jurisdictional police station has been served on the respondent number 2. He submits that since his case involves offense under POXO Act, an amicus curiae may have to be appointed for defending any amicus present in the court may have to be appointed. Stop. Considering the submissions made by learned counsel for the petitioner,
yes,
Legally to পারি legally to পারি appoint করব লাগি
suggested names. Mr. Surajit Das is appointed as amicus curiae to defend the cause of respondent number 2 in this bail application. The registry is directed to furnish the copy of the bail application along with annexures to the learned amicus curiae. Let this matter be listed when? On 25th of October.
Well.
25th of October 2008.
Item 17.
Apply.
Here, my lord, fake gold along with my lord fake currency was recovered from the possession of the petitioner, my lord. Here, my lord, petitioner as on date, my lord, he is behind the bar, my lord, since for 75 days, my lord. Here, my lord, some other co-accused, my lord, from whose possession also, my lord, fake gold was recovered. my
When
lord.
were you arrested?
I was arrested on my lord 21/7/2024, my lord. Page 17 is the forwarding report, my lord. And some, my lord, other co-accused, my lord, from whose possession also, my lord, fake gold was recovered, my lord, has approached this honorable court, my lord. And they are granted bail, my lord, on 49 and 51 days, my lord.
Yes, there is there.
Lordship. Here, Lordship, I want to state here. Firstly, this is an organized crime, Lordship. Moreover, this person is earlier also involved in similar case, Lordship. The case number is also there, Lordship. Again, there are statement 183, statement of with victims are also there, Lordship. Who this petitioner, they identified it, Lordship, in seeing the news in the news channel, Lordship. They identified this petitioner and they stated that this person used to come to their to them. They are the shopkeepers to sell this fake gold, Lordship. But they have not sold, cannot able to sold it because they recognize it as a fake. And at last they assaulted them, Lordship, and took also money. The statement is also there. Lordship may kindly peruse it.
No, now, after 75 days, do you need his detention?
Otherwise, material is there, Lordship, as it
What
is,
is the progress of investigation?
as it is an organized crime, Lordship. Many people are there, Lordship, and the fake currency is also involved in this. So this is a
No,
racket, Lordship.
The offense is,
Fake currency is also there, Lordship.
it was recovered from Shahabul Islam.
This person, Lordship,
Who is the,
this is a petitioner.
Islam is the petitioner.
Fake gold is also there, Lordship, and fake currency is also there. So many persons are involved in this, Lordship. Investigation is going on.
And there was recovery from one Jamir Ali also, my lord.
Moreover, 978 gram of fake gold is found. FSL is also there, it is fake. And moreover, 3,05,000 found fake notes in his possession. Lordship.
from Jamir Ali, only fake gold was found.
Gold was recovered.
This Sahabuddin also, Lordship, this present petitioner.
Mufidul Islam,
He was arrested along with the petitioner, my lord. By the same forwarding, my lord. Already 75 days in custody, my lord.
Habitual offender, Lordship.
now why you require,
He is a habitual offender, Lordship. Moreover, the other person.
whether he will flee away or whether what you apprehend?
For Lordship, who are the persons involved in this case, Lordship? To extract from him, Lordship. Who are the other persons involved in these cases?
To find out
Because he-
other,
Lordship,
there are other co-accused.
other co-accused are also Lordship there.
Already, my lord, so far my knowledge, my lord, two was arrested.
90
my lord,
days is
granted
there,
bail, my lord,
Lordship.
And I will cooperate, my lord, already 75 days, my lord. Any condition, my lord. I will appear before the police station, my lord, as and my lord, call for my lord.
90 days, that means
Only 15 days left. my
15 days left.
lordship.
He will come to police station.
Lordship.
I leave it to Lordship, but I have objection.
Strict condition.
Heard Mr.
K. Burua, my lord.
K. Borwa, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely, what is the name?
Sahabul Islam alias Sahabul.
Sahabul Islam alias Sahabul, who is detained behind the bars since 21/7/2024 within bracket for last 75 days in connection with North Lakhimpur PS case number 195/2024 under section 61 within bracket 2/318 within bracket 4/179 within bracket 179/180/1112 of BNS. The gist of accusation is Code Para 3 from bail application number 2425/2024. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since last 75 days, and in the meanwhile, two of the co-accused who were arrested in connection with this case, namely Muhammad Mofidul Islam and Muhammad Jamir Ali, were already released on bail by this court. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that there are sufficient incriminating materials against the present petitioner. Stop. He has produced the case diary of North Lakhimpur PS case number 195/2024 and has submitted that the offense of possessing fake/counterfeit Indian currency note is an organized offense, and some other accused persons may be involved in the said offense, and to find out their names, the custodial detention of the present petitioner would be necessary. It is also submitted by learned counsel for the learned additional public prosecutor that the present petitioner is a habitual offender, and he has been involved in similar offenses earlier also. So I have considered the submissions of learned counsel for the petitioner and also peruse the case diary of North Lakhimpur PS case number 195/2024. Though there are incriminating materials against the present petitioner in the case diary, however, considering the fact that in the meanwhile, two of the co-accused have already been released on bail, as well as considering the period of detention already undergone by the petitioner, this court is of considered opinion that if the petitioner cooperates with the investigating officer in the investigation, his custodial detention may not be necessary for fair completion of investigation of North Lakhimpur PS case number 195/2024. In view of above, the petitioner, namely Muhammad Shahabul Islam alias Shahabul is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned
CGM
Chief Judicial Magistrate Lakhimpur, subject to following conditions. Condition number 1, 2, and number 3 also, that the petitioner shall appear before the investigating officer of the Lakhimpur PS case number 195/2024 once in every week for next 3 weeks or till the investigation is completed, whichever is earlier. Stop. With above observation, this bail application is hereby disposed of. Send back the case file.
Obliged.
Sword Mr. A. Dhar, learned counsel for the respondents. Both the learned counsel have submitted their written gist of argument. Hearing concluded, judgment reserved. Third, Mr. S.K. Ghosh, learned counsel for the petitioner, also heard Mr.
D. Majumdar, Lordship.
D. Majumdar, learned counsel for the petitioner. Both the counsels have submitted their written gist of argument. Judgment reserved.
Obliged.
Item 68, 62 from supplementary is.
Ms. Chaudhary, today it may be difficult. We are running very slow. We are still in bail hearing motion matter. So it has to be either you will have to wait or we will fix it tomorrow.
Tomorrow, Lordship, same thing will happen, last day of working day of the court, Lordship.
Then
Tomorrow, your Lordship has already fixed delivery of order in 2-3 matters, maybe, Lordship.
then what do you suggest? Because
Lordship can make it part heard and fix after vacation. Already it was part heard, Lordship.
it is part heard
Or I can wait till 3:30, Lordship.
today. Yes. Yeah, wait for some time.
Lordship.
3:30.
After finishing of the list, Lordship.
Okay.
My lord, I am appearing for the respondent number 2. But petitioner advocate informed me he is in another court, so matter for time being possible.
Okay.
Item 58 from supplementary is.
Case diary is there. Case diary is there. Wait. Yes.
Yes, make this is a Lordship. My lord, in this case, I was arrested and forwarded on 12/11/2022, my lord.
12/11/2022. How?
My lord, it is 1 year, 10 month, 21 days as on today. 691 days, my lord, in custody.
What was the contraband?
My petitioner before the Lordship is a driver of a truck, my lord. The professional vehicle, my lord, a public transport vehicle, my lord, and that vehicle was intercepted and 404 kgs of ganja was recovered, my lord. Thereafter, my lord, charge sheet was laid in this case on 28/2/2023. And charges were framed on 9/6/2023, which is at page
Charge
32
sheet was laid on 28,
to 2023, my lord.
charges.
Charges were framed on 9/6/2023. And till date, my lord, only 3 witnesses were examined by the prosecution
Out of
out of 10 witnesses, my lord.
any other co-accused is there?
My lord, the owner of the vehicle was granted bail by this honorable court, my lord.
On what ground he was granted? Where is the bail order?
I'll provide that. I have not annexed with this application, my lord.
Okay.
I'll provide it, my lord. My submission is that, my lord, in this case, already I'm in custody for last 691 days, my lord. And there is no possibility of culmination of trial, my lord, soon. So considering the prolonged incarceration and inordinate delay, my lord, this petitioner's bail may be considered at this stage with any stringent condition.
Yes, Mr. Das.
Yes, Lordship. Firstly, I want to state that Lordship 40400 kgs of ganja has been there, Lordship. This is a commercial quantity. Moreover, FSL give positive report, Lordship. Until now, it is going on a fair pace, Lordship, because the PW1 was give the deposition or given evidence on 15/12/23, then on PW2 6/4/24.
6/4/24.
6/4/24, but I don't know where the
Yes.
PW3 is.
It is on record, my lord. It is on 11/9/2020.
11/9/24.
24.
Then it is on going on fair pace, Lordship. And moreover, one of the seizure witness has implicated, Lordship. And he is in the conscious position of the contraband substance, Lordship.
Okay, heard
There is
Mr.
no delay, Lordship.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Place this matter for delivery of orders tomorrow, that is on 4th of October.
But I have prepared a small compilation of judgments for fair
Give it
evidence.
to me. Along with the judgment of the co-accused
Definitely.
tomorrow.
Lordship, the difference is only that the owner may be, because he is the present petitioner, he is the driver, Lordship.
Yeah, please, Respondent, kindly the matter may pass over for the time being.
Adjourn the matter, Lordship. Kali karo.
Kali.
Mhm.
Kali to नहीं आ रहे, कल वाले बाहर चले लोग आते हैं.
Okay. Okay, after some time we will take.
हाँ, sure.
None appears for the petitioner on call. Let this matter be listed after puja vacation only. On a date to be fixed by registry. None appears for the petitioner on call. Let this matter be listed after puja vacation on a date to be fixed by registry.
May I pay your lordship? Your lordship, in this case, FIR is page 9, your lordship. In the FIR, your lordship's entire allegations and recovery was made from different person, your lordships. I am nowhere. There is no mention my name. There is nothing is there, your Honor, in FIR. Still, my name is figured in the charge sheet, your Honor. Record has been called for, your lordships.
Have you gone through?
Lordship, what I have seen, Lordship, this is a case of ganja, Lordship. Moreover, 7 PWs are there. Cognizance taken on 18/12/2023 under section
What is
20.
the material against him?
Against me, your Honor.
Lordship, against the petitioner is that he purchasing the same with this person from him, the ganja is purchased. This is the person from whom the this person from whom the ganja has been recovered, Lordship. He
No, no,
purchased
not
this.
from me.
From
Not
you,
recovered from me.
not recovered.
Ah.
The person from whom recovered
Ah.
stated that this person from this person he purchased, Lordship. He is the supplier.
Your lordships, in this case, you only whether there is a link. Only because one accused person say against me, whether that can be used against me.
Charge has not been framed yet,
There
Lordship.
must be something, your lordships, on records to connect me with this recovery and the Gaza, your lordships. Only because some accused said independently police
Arguments-
has not got anything.
You go through the records.
Lordship.
Apart from the statement of co-accused,
Lordship.
is there anything on record? Find out.
Lordship. But
You-
charge has not been framed yet, Lordship.
No.
Lordship.
From the record, you find out
Lordship.
whether apart from the statement of co-accused, is
Lordship.
there anything
Other-
else?
Lordship.
If there is nothing, then your case is weak.
Lordship.
Find out.
Lordship.
Let him find out.
Your lordship.
Or you need time.
Which I didn't need time.
Tomorrow is the last date, your lordships.
On reopening day,
Lordship.
Okay, your lordship.
I'm alone today, Lordship, so it become difficult for me.
heard Mr. N. Jha, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor, who submits that he needs some time to go through the scanned copy of the records of the NDPS case number 217/2023 before he makes his submissions. The prayer is allowed. Let this matter be listed on 22nd of October 2024.
May I plead lordship? My lord petitioner, before lordship, 71 days behind the bar. And earlier petition was rejected by the Sonal court. And this is second time, on new ground that the informant expressed her desire to file affidavit in opposition.
What is the offense?
And therefore, offense, my lord, FIR, my lord, that is page 9, my lord. So many section level. Actually, there is no case, and the affidavit in opposition filed by the victim. She stated that affidavit on opposition on record. She stated that she did not sign on the affair, and due to pressure of third party, she stated before the land magistrate.
No, once your prayer was earlier rejected.
Earlier,
Now, what is the new ground?
new ground, my lord, the true fact stated by the victim.
What is there in the case diary?
Lordship, affidavit in opposition on record, my lord, I received copy, and she stated that she has no objection if this honorable court grant bail to the petitioner in connection of dispute case so and so, which was written and signed by another person on my behalf. And I did not sign on the affair, that eventually the petitioner has not committed rape with me and other offences as alleged in the affair. Henceforth, I have not been medically examined in this case. I maintain live together life with the petitioner since 1 year by residing at house number so and so.
Where is the where is the affidavit?
This is the case, my lord, and so far record,
Where is the affidavit?
lordship.
Where is the affidavit?
Affidavit already received, my lord. It is already received. File on 1st of this month.
Yes, Mr. Das. What is it?
And one thing more, my lord, the FIR, my lord, page 11, my lord, this is prescribed format. Here also there is no signature of the informant. Lordship, kindly have a look, page 11. There is no signature.
What is your submission?
I am appearing respondent number 2.
Victim? You have no objection?
No objection.
Mr. Das?
I only wanted to state that there
Oh,
is no
affidavit.
compromise. This is a not compounding section, lordship.
No.
Moreover, in 183, she have clearly implicated lordship. If she have, I leave it to lordship. But my objection is only on that point. Legally, lordship, there is no compounding is there. Moreover, she has implicated in 183 of the BNS Act, lordship. And on that ground only, the earlier bail was 9/2024, and the present last date entry is 8/9/24. So no new ground is there, lordship.
Eventually, no incident was happened. And therefore, my lord, this FIR, my lord, page 13, written by somebody else, and this signature also she denied. And so far prescribed format is concerned, and section 173 of BNSS Act, it is mandatory to put signature of the victim or informant. There is no signature.
Mr. What is your name? What is your name? Mr. K. Bhuya, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor, as well as Mr.
R.K. Talukdar.
R.
Ronendo Talukdar.
R.K.
R.K. Talukdar.
R.K. Talukdar, learned counsel for the victim. This application under section 483 of the BNSS, 2023 has been petitioner Sahid Ali, who has been detained behind the bars since 24/7/2024 for last 71 days in connection with dispute PS case number 755/2024 under section 127 within bracket 7/64 within bracket 1/76/75 within bracket 2/308 within bracket 4/304 within bracket 2 of BNS 2023. The gist of accusation in this case is code para 3 from page 17. The counsel for the petitioner has submitted that earlier also the petitioner approached this court. However, on that occasion, his prayer for bail was rejected by this court in bail application number 2585/2024. So he has submitted that the petitioner is having consensual relationship with the victim since last 1 year, and the allegations made in the FIR are not true. He has also submitted that the victim girl has also filed an affidavit in this case, wherein she has stated that that she has not written and signed the FIR and same was written by some other person. And the petitioner did not commit any rape with her. It is also submitted that the victim girl is in live-in relationship with the petitioner since last 1 year. And she has no objection if the petitioner is released on bail. Stop. On the other hand, learned additional public prosecutor, case diary is there. Learned additional public prosecutor has submitted that in the case diary, there are implicating materials against the petitioner. And hence he has opposed the grant of bail to the petitioner. The counsel for the victim girl has submitted that the victim has no objection if the petitioner is allowed to go on bail. Stop. Considering the facts and circumstances of this case, as well as considering the materials in the case diary from an affidavit submitted by the victim girl, as well as the fact that the petitioner has already been detained behind the bars for last 71 days. His further custodial detention does not appear to be necessary if he cooperates with the investigating officer in the investigation of the case. Hence, in view of above, the petitioner is hereby allowed to go on bail of rupees 30,000 with one surety of like amount,
CJM Kamrup Metro.
subject to the satisfaction of learned Chief Judicial Magistrate Kamrup Metro with following conditions. Condition number 1 and 2. This bail application is accordingly disposed of. Send back the case diary.
I love this.
Yes, please, your lordship. Dr. As per which no clear sheet has been received, lordship. Matter may fix for hearing, lordship.
Heard Mr. What is your name?
And board, lordship.
L. Boga, learned counsel for the petitioner. Also heard Miss
L Sharma.
L. Sharma, learned counsel for respondent,
For number 2, my lord, insurance, my lord.
respondent insurance company. The service is complete and the records from the concerned tribunal has been received. This case is ready for hearing. Let this matter be listed for hearing after.
Lordship, just after vacation, lordship, that may be kindly fixed, lordship. It's a long pending matter, lordship.
As usual.
Lordship,
No, you-
2016 since 2016.
2021. You have to file an
Yes, lordship.
application for expeditious hearing. Let this matter be listed for
Listing for our country.
hearing after Puja vacation on a date to be fixed by the list.
Obliged, my lord.
Also, this matter has been admitted and also stay has also been granted. This
Now, why it has come up for orders,
also it should have come for hearing.
but it is in orders column.
Yes, lordship. Present.
This case heard Mr. R. Goswami, learned counsel for the appellant. None has appeared for the respondent. This case is ready for hearing. List this matter for hearing after in its usual course.
Yes, sir. And then also the LCR has come also.
LCR has come.
Yes. Obliged. May I please be reload. Reload, this I is filed for release of 50% of the awarded amount that is.
Any objection?
Lordship, only objection is that they had, that may be released, lordship, subject to furnishing indemnity bond.
Heard
Because
Mr. A. R. Agarwal, learned counsel for the applicant slash claimant, also at M. Chaudhary, learned counsel for the insurance company. This application has been made by the applicant slash claimant, praying for allowing the petitioner applicant to withdraw the 50% amount of the awarded compensation deposited by the insurance company before the registry of this court. The learned counsel for the respondent does not have any objection subject to does not have any objection to the same. However, she submits that the petitioner, the applicant may be directed to furnish indemnity bond to the tune of the released amount. Stop. Considering the submissions made by learned counsel for both the sides, the prayer is allowed. The registry is directed to release the 50%, release the amount deposited by, release the amount within bracket, rupees 13,85,787.
Without any rider loads. Because the injury case loads,
To the,
without any rider.
to the, no. To the to the applicant claimants on furnishing of indemnity bond to the tune of the released amount after proper verification. This interlocutory application is accordingly disposed of.
Lordship, without any
Lordship,
rider.
so far as appeal is concerned, Lordship, the service report of 2 and 3, Lordship, has been received back. It has not yet been received back, maybe awaited, Lordship.
Heard Mr.
I am for the
No,
appellant,
I heard Miss M. Chaudhary, learned counsel for the appellant. Also heard Mr. A.R. Agarwal, appearing for respondent
number
number 1. It appears from the office note
Dated 9/2/24, Lordship.
dated 9/2/2024 that service report in respect of respondent number 2 and 3 has not yet been received. Await for the same.
Lordship,
Release this matter after Puja vacation.
Lordship, must oblige, Lordship.
Lordship in the release, Lordship, because
No.
in the injury case, Lordship.
No, I have not mentioned any rider.
Yes.
So whatever I have mentioned, that will be followed.
That is your side.
As per office note dated 17/5/23, respondent was 2 and 4 appeared, and 1 and 3 are visually awaited. Lordship, I may be allowed to take press.
Heard Mr.
AKR.
A.K. Azad, learned counsel for the petitioner. Also heard Mr. N. Chaudhary, learned counsel appearing for
Respondent number 4, my lord.
respondent number 4. The office note dated 19/5/2023 shows that the notices issued to respondent number 1 and 3 have not been received back. Stop. The petitioner, learned counsel for the petitioner prays for allowing the petitioner to take, not petitioner, appellant to take fresh steps for issuance of notice on the said respondents. The prayer is allowed. The appellant shall take fresh steps for service of notice on the aforesaid respondents within 7 days from the date of this order by registered post with AD as well as by usual mode returnable on 13th of November 2000.
It is an interim order, my lord, in IAP.
The interim order in interlocutory application, the interim order shall continue till next day.
Oh, let's deeply oblige.
May I please, Lordship, kindly peruse office note dated 13/8/2024, my lord. Answer notice on respond number 2 has been received with postal remark, my address is out of station, my lord. But in service report regarding notice, my lord, await service, my lord. Let my lord await service. Thereafter, we have
Heard Ms. L. Sharma, learned counsel for the appellant. On perusal of the office note dated 13/8/2024, it appears that the notices issued to respondent number
Two.
2 by usual mode has not yet been received. Await service report of notices sent through usual mode to respondent number 2. Place this matter after 4 weeks.
oblige no.
May I please, Your Honor? Steps have been already taken, but in the office note dated 13/9/2024, it has been mentioned that they have refused to accept the notice. It may be presumed that they had already accepted, but they have, in that case, they have refused to accept the notice.
Putul, the return notice has come. Mr. What is your name?
D. Goswami.
D. Goswami, learned counsel for the petitioner. On perusal of the office note dated 13/9/2024, some 39/2024. It appears that the notices sent to respondent number 1 to 5 has returned with an endorsement, refused, within inverted comma, refused, return to sender. In through usual mode.
That's it.
Okay. Considering the office note, the notices issued to respondent number 1 to 5 are deemed to be duly served. Let this matter be listed for admission hearings after puja vacation on a date to be fixed by registry. No date.
May it please your lordship. Here, the respondent number 1 has been struck off, and in regard to service of respondent number 2, we have to take fresh steps.
Heard Miss
D. Devi, on behalf of S. Datta.
D. Devi, learned counsel for the appellants. Also Miss L. Sharma, learned counsel for
respondent number 3.
respondent number 3. Learned counsel for the petitioner, learned counsel for the appellant has submitted that some more time may be granted to take fresh steps for issuance of notice on respondent number 2. The prayer is allowed. The appellant shall take fresh steps on respondent number 2 within 7 days from the date of this order, returnable on 13th of November 2008.
May I please, Lord? My lord, appeal has been filed by the insurance company, my lord. My lord, appeal has been admitted. My lord, I have filed a interlocutory application for releasing the already deposited amount, my lord. My lord, my IA is, my lord, IA number
Do you
37.
have any objections?
Lordship, our submission is that up to 15 lakhs, Lordship, we have no objection. We have deposited 22 lakhs, Lordship, 50%. Beyond that, Lordship.
Why?
Lordship, our stand is that if the stand taken by us in the appeal are allowed, all the appeals, all the grounds, Lordship, that amount may not come above 15 lakhs, Lordship.
Okay, then take 15 lakhs.
My lord, only my submission is, my lord, your lordship kindly see the ground of the appeal and what ground they have filed the appeal. My lord, learned tribunal, my lord, assess the income tax return of the deceased.
No, you take 15 lakh, 5 lakh will remain here. Ultimately, if the appeal is,
My lord, they have deposited, my lord, 28 lakhs.
no, it will be in registry. Heard. The appeal is ready for hearing.
My lord,
Lordship,
record has come, my lord.
in respect of only respondent of 5 service is not complete. That is the only issue, Lordship. The main appeal may be sent to the large enough court to ascertain service on respondent of 5. Otherwise, everything is ready, Lordship.
My lord, my submission, my lord, they have deposited 28 lakhs. My lord, 20 lakhs may be released, my lord. Not 15 lakhs. My lord. In
How you have calculated that it will come to 15 lakhs?
So that their income was Lordship, income tax return was submitted, but that was not proved, Lordship, duly.
My lord, this is the, my lord, public document, statutory, my lord, document, my lord, need not to be, my lord, proof, my lord. My lord, exhibit 6 is the, my lord, return, my lord, certificate, my lord. A Manna.
A Mannan, learned counsel for the applicant. Also heard Mr. A.J. Sakya, learned counsel for the opposite party appellant. This appeal, this interlocutory application has been filed by the applicant claimant for allowing the applicant to withdraw the 50% of the awarded amount, which has been deposited by the appellant before the registry of this court, which is to the tune of rupees. How much comes to 50%? How much you have deposited?
My lord, 50% comes, my lord,
50% from Lordship, 22 lakhs, Lordship,
My lord-
22 lakhs 53,500.
my lord, with interest they have deposited, my lord.
22 lakh 53,500 stuff. Learned counsel for the opposite party appellant has submitted that the appellant, the opposite party appellant, which is the insurance company, has no objection if an amount of rupees 15 lakhs is released to the applicants, as there is a probability that in the event the appeal is allowed, the awarded amount of compensation may be reduced to the extent of rupees 15 lakh. Stop considering the submissions made by learned counsel for the opposite party applicant. The prayer for withdrawal of the deposited amount is allowed to the extent of rupees 15 lakhs only. The remaining amount shall remain deposited in the registry. The registry is directed to release rupees 15 lakhs to the claimants as to the applicants slash claimants after proper verification. This
My lord, only submit, my lord, they have, my lord, deposited, my lord, 50% along with interest part, my lord. Total amount they have deposited 28 lakhs, my lord, 28 lakhs,
okay, whatever deposited, it is already there.
my lord.
28 lakhs,
28 lakhs, 28,050. They have deposited along with interest.
amount total, 28 lakhs, 28,050. In appeal, heard Mr. A.J. Soikel, Lanet counsel for the appellant. Also heard Mr. A.
Manna.
Manna, Lanet counsel for respondent number 1, 2, 3. It appears that the notices issued to respondent number 5 has not yet been received back. The records of the concerned MSC case has been received from the concerned tribunal. So let this matter be listed before Lawazima court to be listed again before the regular court after completion of service of notice on the respondent number 5.
Item 36.
Please, your lordship. My senior counsel is on legs, yeah, in court number 2, your lordship. And your date may be fixed after vacation.
Heard Miss,
Your lordship, interim order may kindly be continued.
what's her name?
P. Sharma, on behalf of
Heard
petitioner.
Miss P. Sharma, learned counsel for the petitioner. Also heard Miss
S. Jain.
S. Jain, learned counsel for the respondent. On request of learned counsel for the respondent, this case is adjourned for today. Let this matter be listed after Puja vacation. The interim
Leave
order
may
shall
fix, your
continue.
lordship.
The interim order shall continue till next day.
Obliged. It may come up with the I.
Hmm.
It may come up with the I, your lordship.
Or let this interlocutory application be listed along with PRT 68/2024.
Obliged.
Item 47.
May I please, your lord? Well, and, they have not yet filed an affidavit regarding our contention. And I pray that matter may become after vacation. my lord. Interim order is there, my lord.
Why it has come up for orders today?
Notice that they have appeared, my lord.
Only one. How many respondents are there?
Sole respondent.
Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Islam appearing for the sole respondent. Records would be necessary.
My lordship may peruse because they have not challenged this no, service of the notice. That's why learned family court judge has considered. The notice was duly served, but she did not appear. Actually, after the judgment, she has filed a IA miscase matter before the family court that notice was not served.
No, respondent only prays to get the opportunity to have the matter filed by the petitioner.
Law is settled. If the honorable court has passed the order after considering all the aspects of the matter.
Let this matter be listed for admission hearing
Yes.
after Puja vacation.
Interim order is there. That may
The
continue.
interim order shall continue till next day.
My lord, I filed the objection today itself because, my lord, I was out of station. That's why I could not file my objection come affidavit in advance, my lord. And
Lordship,
perhaps
we-
that has not been placed in the record, my lord.
We are the appellants, Lordship, anyway, the suit property has to be protected, Lordship, till disposal of the appeal. And their Lordship contention in the affidavit in objection, I have seen that they already constructed Pakka house since before the filing of the suit. So
Then,
if
my lord,
if they are
even,
admitting, then status quo, Lordship. They have
my
not-
lord, let my objection and come affidavit, let it taken up tomorrow, my lord.
Call করাই দিব, এই যে হবে।
After puja vacation. Now,
Under
this
injunction,
is,
they might
this is,
call-
you are praying for stay of execution,
No,
then
injunction, not to
Injunction.
raise any
Injunction.
construction.
Not
But
raise any
my plea is
further
that I have, they have
already
constru-
raised.
whatever construction has been made, it is even before filing of the suit,
So
not
status quo,
now.
Lordship, they will not be affected.
not now. So when there is no construction as on today, then where is the,
If they are
Therefore,
possessing,
injunction.
Lordship, their possession may be protected and Lordship till the decision of the second appeal.
my lord, let my
No,
objection,
let his objection come.
That's
it-
tomorrow, Lordship. I was under impression they might have called the objection, Lordship.
no, no, I have,
vacation.
yes,
Because they have already constructed.
No, that was before, their contention is that was before filing of the suit. And we have
There
filed
is
the
no new
injunction
construction.
petition that we have filed an FIR.
their allegation is that I have raised construction.
Heard Miss R. Chaudhary, learned counsel for the applicant. Also heard Mr. R. K. Jain, learned counsel for the opposite party, who submits that the opposite parties have filed their written objection, same may be tagged with the case record. He also submits that the construction in the suit land was before filing of the suit, and no new construction has been made in the suit land. Considering the submissions made by learned counsel for the parties, let this matter be listed along with the, after tagging the objection filed by the opposite party on reopening on 23rd of October 2009.
My lord,
Lordship, in regard to item number 62, may be taken after vacation, Lordship. And we have consulted with appellant also.
Suggested date. After vacation, it has to be in the month of November.
Lordship, 5th of November then. It's a Tuesday, Lordship.
Heard Miss R. Chaudhary, learned counsel for,
Respondent, Lordship.
no, heard Mr.
Arsham.
R. Sharma, learned counsel for the appellant. Also heard Miss R. Chaudhary, learned counsel for the respondent. Due to paucity of time, this matter could not be taken up for hearing today. With all with consent of learned counsel for both the sides, let this matter be listed on 5th of November as part heard matter.
Lordship, until your honor.
Yes.
Right, Regan. Can you please, office note dated 19/9.
How many respondents are there?
There are altogether 20 respondents. Out of that, 7 respondents filed wakalatnama. And regarding respondent with 3, 13A and 13B has not served.
Who have filed wakalatnama?
1, 2, 4, 5, 6, 7 and 8.
Heard Mr. A. Kabra, learned counsel for the, whether their names have been shown. This is item number,
39.
okay. Heard Miss A. Kabra, learned counsel for the applicant. None has appeared for respondent number 1, 2, 4, 5, 6, 7, 8. though names of two counsel have been shown in the cause list as engaged counsel for the said respondents. On perusal of the office note, it appears that the notices sent to respondent number 9 have been returned with a postal remark within inverted comma, refuse, stop, return to the sender, stop. In view of the said endorsement, the notices issued to respondent number 9 is deemed to be duly served, stop. As regards respondent number 3, three 13A,
There is a remark addressee out of station.
the postal, the notices have returned with postal endorsement addressee out of station, returned to the sender. As regards notices issued to respondent number 13A and 13B, the AD card have returned back without any signatures of the addressee thereon. And no AD card or unserved notice have been received back in respect of respondent number 10, 11, 12, 13C, 14, 15, 16, 17, and 18. The applicant shall take fresh steps for issuance of notice on respondent number 3, 13A, 13B, 10, 11, 12, 13C, 14, 15, 16, 17, and 18 by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. This accordingly.
Wait, please. Yes, dear my lord, respondent number 4 has died, my lord. I have filed an application for substitution along with delay contribution in setting up. Notices may go, my lord. First time someone.
Heard Mr. P. Sundi, learned counsel for the
Yan Borwell also. For respondent 1, 2, and 3.
applicant. Also heard Mr. M. Bora appearing for respondent number 1, 2, and 3. This application under section 5 of the Limitation Act, 1963 has been filed for condoning the delay of 464 days in filing the application for setting aside of abatement on date of
Respondent number 4, my lord.
respondent number 4. Issue notice to the respondents who are not represented in this case. The applicant shall take steps for issuance of notice on the aforesaid respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 14th of November 2010.
May it please last, my lord. 41, my lord, that this application is for the substitution of the applicant number 1, my lord, who died on 15/11/2023. So it is in time, my lord. With legal years, presently here 6 applicants, my lord.
Within limitations, you have filed the application within limitation. Yes. Any objection?
Lordship, we have not received any copy, Lordship. Newly filed,
No, my lord.
IA.
Applicant number 1 died, it is in time, so I have filed an application for it. He is not responding, is not responding in respect of this appellant number one, my lord. So he could not understand, follow the matter, my lord.
Respondent.
আমি appellant number one to get.
Do you have any objection?
Lordship, I'm for the respondent. We have not
For
received.
other
any-
respondents, my lord. Appellant number one that I am for the appellant, my lord. So I have filed application for the legal substitution of the legal
Mr.
heirs.
M.H. Raj Borgmia, learned counsel for the applicants. This application under order 22, rule 2. Under order 22 rule. Of the Code of Civil Procedure, 1908 for substitution of the legal heirs of appellant number 1, late Moyur Ali Borgmia, who had expired on 15/11/2023. The application has been made within the period of limitations. The legal heirs proposed to be substituted in his place are the sons and daughters of the appellant number 1. Learned counsel for respondent number.
Respondent number. Twelve, Lordship.
12. Who is present, does not have
Lordship,
any.
1 to 12.
1 to 12. Are you sure whom you are representing? What is your name?
M.H. Ali on behalf of Mr. A. Shahad.
Since the application has been made within the period of limitation and as the as the proposed as the legal heirs who are supposed to be substituted are the sons and daughters of the deceased respondent number 1, where is allowed. The registry to substitute the names of the legal heirs of respondent number 1. As where have you mentioned the names of legal heirs? As mentioned in paragraph number 2 of this application, in place of respondent number 1 as respondent number 1A to 1G. Stop. This interlocutory application is accordingly disposed of. List the connected second appeal after making substitution in person to this order. List after puja vacation.
Obliged, Lordship.
Well, another matter, your lordship, another application, 845 matter, and another IA is also there. In respect of the, this is in respect of the on death of the respondent number 12 matter. There was a delay of 2 days. This delay has been condoned. So notice may kindly be issued, my lord.
In 845. This application under order 22 rule 4 has been made by the appellant for substitution of the legal heirs of respondent number 12 on death of respondent number 12, issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by registered post with AB as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
In this case, my lord, the applicant insurance company has deposited 50% amount, my lord, and the interest application filed by the claimant, my lord, for allowing them to do the same, my lord.
Do you have any objection?
No objection.
Heard Mr. S. Rahman, learned counsel for the applicant, also heard Mr. T. Kolita, learned counsel for the insurance company. This application has been made by the applicant slash claimant for allowing the applicant slash claimant to withdraw the 50% of the awarded amount. The awarded compensation which has been deposited in the registry by the appellant insurance company. So the learned counsel for the insurance company does not have any objection to the prayer made. In view of above, this application is allowed. The registry shall disburse the 50% of the awarded amount which has been deposited by the appellant in the registry of this court after proper verification to the applicant slash claimant.
My lord, the applicant to a minor, my lord, so applicant number 1 may be allowed.
As applicant number 2, who is minor?
2, my lord.
As applicant number 2 is minor. 1 is her mother.
Mother, my lord.
His mother, that is applicant number 1, Srimati Savita Mandal, is allowed to receive the deposited amount also on behalf of applicant number 2. This interlocutory application is accordingly disposed of. What is main AP?
Lordship, there is a delay of 31 days, Lordship. The delay was not
Delay has been condoned.
not condoned, Lordship.
Delay has not been condoned.
Delay condoned, Lordship. Delay condoned, my lord. Delay condoned, my lord.
You are appearing for respondent number
In 1 and 2.
1 and 2.
And respondent number 3 is the owner cum driver, Lordship.
Heard Mr. T. Kolita, learned counsel for the appellant. Also heard Mr. S. Rahman, learned counsel for respondent number 1 and 2. The notice is issued to respondent number.
Lordship, I am here, Lordship, that appeal is on the basis of quantum, Lordship. So that the name of the respondent number 3 may be struck out.
Has not yet been received back.
Yes.
Learned counsel for the appellant has submitted that the presence of respondent number 3 may not be necessary for. Who is the appellant? Who is the respondent number 3? Owner.
Respondent number 3 is the owner cum driver.
Then notice has to be.
Lordship, the ground of the appeal is only the selective quantum, Lordship.
But you are paying on for respondent number 2 only. Respondent number 3 only. You are indemnifying him. Then no,
That's respondent number 3, Lordship.
you have to take fresh steps.
Lordship.
The notices issued to respondent number 3 has not yet returned. Await further. Let this matter be listed after Puja vacation on a date to be fixed by registry. Yes.
My lord, the school appellant has expired
on 22/8/2014.
22,
8,
8,
2014,
14.
to 24 of my lord. And petition filed within time, on 29, this petition. has been
Any
filed.
objection?
No objection.
Heard Mr. J. Ahmed, learned counsel for the applicant. Also heard Mr.
And
Yes.
Brahma Lordship.
S.
And Brahma Lordship.
N.
Appearing
Brahma-
on behalf of G. Bharadwaj Lordship.
N. Brahma, learned counsel for the respondents. This application has been made under Order 22, Rule 3 of the Code of Civil Procedure, praying for substituting the legal representative of the sole appellant who had expired on 22/8/2024. Stop. Learned counsel for the applicant has submitted that the application for substituting the legal representative of the sole respondent has been made within the period of limitation, and the applicants who are the legal representatives of the sole appellant may be allowed to substituted as appellant. Learned counsel for the respondent does not have any objection. Stop. Considering the submissions made by learned counsel for the parties, the prayer is allowed. The names of the applicants who are the legal representative of the sole respondent,
Appellant.
sole appellant, Firdaus Ali, who expired on 22/10/2024, may be substituted as appellant number 1 to 18 in this appeal. Their names may be substituted in the memo of appeal. You file a,
Corrected petition.
no, the last line to cut it, no? Then the applicant shall file a corrected memo of appeal, corrected cause title of the memo of appeal by incorporating the name of substituted legal representative of respondent number 1.
Appellant.
Appellant number 1 within a week from the date of this order. List the connected appeal after furnishing of the corrected memo, cause title of the memo of appeal after puja vacation. The IA stands disposed of.
Happy Lordship. Lordship, I file this IA for withdrawal amount deposited by the insurance company, Lordship.
Any
No objection, my lord, was submitting a bond, my lord, bond paper.
Third,
There.
Mr. R. Sharma, learned counsel for the applicant. Also heard Ms. L. Sharma, learned counsel for
Respondent number 1.
Respondent number 1, insurance company.
Yes, ma'am.
This application has been made by the applicants / claimants for withdrawal of rupees 11,59,924, which has been deposited by the appellant insurance company before the registry of this court in compliance with the order dated 22/5/2024 passed by this court in IA number 1462/2024 arising out of MSC appeal number 219/2024. Stop. The learned counsel for the insurance company does not have any objection to release of the said amount. Our only submission is that an indemnity bond may be furnished by the claimant applicants at the time of receiving the deposited amount. Considering the submissions made by learned counsel for the parties, the prayer is allowed. The registry is directed to disburse the deposited amount of rupees 11,59,924 to the applicants slash claimants on furnishing of indemnity bond to the extent of deposited amount after proper verification. This interlocutory application is accordingly disposed of.
In main appeal, my lord, service may be awaited on respond number 4, 5, 6, and 7, my lord.
In main appeal, heard Ms.
L.
L. Sharma, learned counsel for the appellant. Also heard Mr. R. Sharma, learned counsel for the
Respond number
1, 2, 3.
respondent. Number 1,
2, 3.
2, 3. 1, 2, 3. 2 is
Lordship.
also your representative.
Lordship.
On perusal of the office note dated 30/9/2024, it appears that the AD cards in respect of notices issued to respondent number 4, 5, 6, and 7 have not been received back. Await further. List this matter after puja
Okay.
vacation.
Obliged, my lord.
Lordship, there is an IA for condoning the delay of 5 days, sir, in filing the regular form of appeal. Lordship, may issue of appeal.
Heard Mr. B.P. Bora, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of 5 days in preferring the connected first appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 13th of November 2020.
May it please your lordship. On earlier occasion, we are unable to take.
Third means, what is your name?
Yes, Musa.
S. Mushahari, learned counsel for the applicant. You need some more time.
Yes, my lord.
Who prays for some more time for taking steps for issuance of notice on respondent number 5
5.
through paper publication. The prayer is allowed.
My lord, in one paper, that is Mokokchang Times.
The prayer is allowed. The applicant can take steps for issuance of notice upon respondent number 5 through paper publication in a local newspaper published having circulation in the state of Nagaland. In the state of Nagaland within 7 days from the date of this order. The date of notice mentioned in the date of appearance of the respondent to be mentioned in the notice shall be 13th of November,
My lord,
13 November,
13 November.
date of notice. Before that, you have to publish.
Yes, sir.
List this matter again after 13th of November.
Obliged.
Report of the meeting. ड्राइवर में प्राइवेट कार में
ये तो अपना रीजन तो देख लीजिए हाँ क्यों
frame my it is in the file.
report is there, Lord.
It is what case? NDPS case?
Yes,
When were you arrested?
arrested on 7/1/24. 2 days, 270, about 9 months. His case is my dad, he is the driver of a wagon car, private car. His owner has sent him with a friend from Silchar to Patakhana. On where, my lord, the back side of the seat, one of these things were found. Petitioner, he was a driver and that person was sitting along with him, my lord, in the front seat. It was found in the back seat, my lord. Now, whether it is conscious possession of the petitioner or not, this is the only thing. Whether 42 complied or not. Only on these 2 points, my lord. It is sunset, my lord, 5:30, they got information. Seizure is about 7:30. And at that point of time, my lord, it is 5 PM, the sunset, my. So 4:40, my lord, your lordship, 42. You don't see.
No, what is your case? That 42 to.
My case is 42, my lord, that is not, he is to inform the written ground proviso 42 proviso if he within 72 hours to the higher officer. Whether that has been done or not, to my information that has been done. So it is a violation of 42, and your lordship also held in so many cases also. That is mandatory. So if that will reveal only from that, my information, my that has not been done. A second question, conscious possession. Conscious mean I must active, I must have knowledge about that here. Another person was there. And that person also, my lord, he was also arrested, my lord, that. Owner is one Haripada Saha. And another passenger is Demand Bhattacharya. Demand Bhattacharya. A petitioner is a Kumarjit there.
Have you gone through the records?
Lordship, what I have seen, Lordship, on earlier occasion, one report was called for why the charge sheet has not been, charge has not been framed. That report is there, Lordship, and charge has been framed on 28/2024. You but a lecture there, as Larned Senior Advocate has stated, the Lordship, that he is in the conscious possession, Lordship, in the car, in the rear side of the, in the concealed position. Lordship.
No.
And
Regarding
Lordship,
that 42.
I have not
compliance.
checked on that particular point, Lordship, but I have seen one after obtaining written authorization letter. Authorization letter was there, Lordship. In the FIR itself, it is stated, Lordship. Because as per 42 authorization letter is should be there. If we look into the Lordship FIR, it is stated here, Lordship. After obtaining or written
Okay,
authorization
then-
letter,
Because we have to go through.
Lordship.
Your worship, your worship was any order. Poor driver murder is behind the bar about 9 months, man. In fact, the other person was there, man. And in paragraph 5, I have stated details, man. I am a salaried person, man. Paragraph 5 of my petition. The back seat, whether it is conscious possession or not.
Okay, make your submission.
Lordship, in the FIR also, Lordship.
No, what are your submissions?
Now, my lord, you will kindly see paragraph 5.
Verify.
Yes. Actual fact of the case that the petitioner is the driver of the wagoner whose owner name is Haripada Saha of Silchar.
petitioner is a salaried driver of the Haripada Saha. As a driver of the vehicle, the petitioner is assigned with duties by his owner. On the alleged day of the occurrence, the petitioner was asked by his owner to drop his fan from Silchar to Patakhandu. And the petitioner drove the occupant Divan Bhattacharya. And on midway, the police ignored the car. On stopping the same, the police asked the petitioner to come out for routine checking and asked him to cooperate, which the petitioner did. And the alleged contraband were found from the full bag of the Divan Bhattacharya. It is his bag, Divan Bhattacharya. The petitioner had no idea that the said person was carrying banned substance. The petitioner categorically denies any involvement in the alleged offense, or any knowledge of the presence of contraband in the bag. Mr. Kita, he does not know the occupant personally, and he only knew that occupant was the owner's friend. Then my paragraph 6. Police officer conducting the search and the seizure procedure is without following the due procedure law. Proviso to section 42 states that there has to be a special reason while conducting the seizure and procedure before the sunrise and sunset, and the same is mandatory. But in the present case, there is nothing on record that the informant obtained prior permission from the authority to conduct the search and seizure in the car which the petitioner was driving. Neither he stated in the FIR the reason which led him to conduct before sunrise and after sunset, and as such, provided the mandatory provision of sunrise. So basic thing about whether 42 is complied or not. 42, my lord, proviso, second proviso, if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of the evidence or facility, he may enter such building, conveyance, or enclosed place of any time between sunset and sunrise after recording the grounds of his belief. And where such officer takes down an information in writing under subsection 1 or records grounds for his belief under the proviso, he shall within 72 hours send a copy thereof to his immediate official secretary. Whether that has been done, if that is done, my lord, I have nothing to say. So far, this point is concerned. The other point about conscious possession. Whether does it amount to conscious possession?
Lordship, if I, in page 30, Lordship, charge sheet is.
Conscious possession defined, my lord, 2015, 6 SCC 222. 2015, 6 SCC 222. Paragraph?
What it says,
Paragraph 21.
what it says.
Mohalla.
Para? Paragraph?
Giving the copy. 20. 21. Page 238, man. Mohanlal case, man. From the aforesaid exposition of law, it is quite vivid that the term possession, your lordship, for the purpose of section 18 of the NDPS Act would mean physical possession with animus, your lordship, and with animus, custody or dominion over the prohibited substance, with animus or even the exercise of dominion and control as a result of concealment. The animus and the mental intent, which is the primary and significant element to show and establish possession. Further, personal knowledge as to the existence of the chattel, that is illegal substance, at a particular location or site at a relevant time, and the intention based upon the knowledge would constitute the unique relationship and manifest possession. In such a situation, presence and existence of possession could be justified, for the intention is to exercise right over the substance or the chattel and to act as the owner of the to the exclusion of the others. So animus, my lord, possession with animus. That is paramount consideration.
No, but that would be decided in the trial only.
No, in the bail petition also this can be done, my lord. Your lordship will see that Sarija's case. While considering bail petition, my lord, if mandatory provisions are violated, if main things are there, but on the face of it, 37, prima facie there is a chance of acquittal or there is no. Then in that case, my lord, your lordship may consider while considering bail also, my lord. 2004, 12 SCC, 266. Your lordship will find paragraph 6 to 8. 2004, 12 SCC, 266. Paragraph 6 to 8. While considering bail, my lord, your lordship also may consider bail.
Okay.
So this is basically my point, my lord. Conscious possession, prima facie, my lord, 37 is not applicable. That is my humble submission. The rest I leave to your lordship.
Lordship, if I look into the charge sheet, Lordship, page 30. The second line, Lordship. May I read, Lordship? 30. As such, complainant was duly authorized by the officer in charge of Karimganj PS, height so and so, dated as per the provision of section 42 of NDPS Act to carry out the operation along with the team, so and so, Lordship. Prima facie, Lordship, it is stated here. Moreover, it is 5:30, whether it is sunset or not, it will came up in the during trial, Lordship.
No, it is, everybody knows. January, my lord, when sunset comes.
No, where from record we can find out that whether it was.
Calendar is my lord, there, my lord, I can produce your lordship. Timetable is there. We do prayer at that time, that way, we know it.
That would be necessary.
Yes, 5:30. It is 5:30, but it is at 5 PM, January month.
No, but from record has to be there.
No, record 5:30, it is their own. Then calendar, I'll show to your law, you submit to your lordship. 7:30 the seizure. That means 5:30 they got the information, man.
Seizure is at 7:30.
7:30, page 16. Page 16. Middle portion, date and time of seizure. Page
Mr.
1.
Das, you find out from the scan copy of the case diary whether any reason has been shown for conducting search after sunset.
With respect to this case.
Yes, with respect to this case only.
Lordship.
Whether any reason has been shown.
Lordship.
When will you find?
Tomorrow, my lord, because vacation is there.
We have some.
The poor person, salary driver, my lord.
You find out tomorrow.
Lordship, I will try, Lordship, because we have some scarcity of APPs, Lordship. We have to, for 3 courts, I have to look into it, Lordship. If I get Lordship, I will definitely.
Yes, I will help you.
Lordship.
Or let it be after vacation.
If possible, my lord.
You
If
try
my Nana friend is
tomorrow.
not prepared, my lord, we
You
will
just
see.
find out whether any reason has been shown for conducting search and seizure after sunset.
Lordship.
Is there any document?
Well, that
in
he
the
can do
case
today,
diary?
my lord.
That much.
Oh, my
Third, Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that he needs some time to go through the scanned copy of the case diary. Case diary's scanned copy is there.
Lordship, I think so. It is there.
Scanned copy of the case diary before making his submissions, reply submissions in this case. The prayer is allowed. Let this matter be listed again tomorrow, that is on 4th of October 2008.
At 2 PM, my lord.
No, 2 PM cases, there are many 2 PM cases.
Anyway, madam.
Tomorrow we'll take it up.
Anyway, anytime, my lord.
Tomorrow.
Item number 8.
Need please, my lord. One of this revision petition was filed seeking under the supervisory jurisdiction.
Who is
of
for
the-
the other side?
My lord, for the respondent cooperative society liquidator has been appointed. The liquidator has submitted its report before this court. It is at flag M in the file.
Flag?
M.
Okay, okay, no, you make your submission. Flag M.
My lord, here in this case, the petitioner sought to invoke the supervisory jurisdiction of this court under Article 227. The arbitral award was granted in favor of the petitioner firm in the year 1999, and thereafter money execution was filed accordingly before the trial court. We in the year 2009, until date, no proper recovery of the money has been made for the money execution case.
No.
However, recently,
What you are impugning?
impugning means several of orders were passed whereby my lord, whereby the Nazir was sent, but however, no report could be retrieved.
So what you have challenged? You are challenging a
Just to expedite the process, no challenge has been made, my lord. Only the supervisory jurisdiction of the court has been invoked in order, praying for an order of expeditial disposal, since it has been pending for the last.
Why
since
it is,
2000.
why, where is the hindrance? Why it is pending? Execution case is pending.
My lord, after the appointment of the liquidator, on several days the Nazir was sent, but no report was filed because the liquidator time and again sought for time in order to clear the arbitral dues. Otherwise, the response of the liquidator, which is available before this honorable court, the dues as per the arbitral tribunal have been accepted herein as well.
Has been
Accepted, my lord.
accepted. Then where is the problem?
Till on paper, my lord, it has been accepted, but till date, the amount which is to be deposited in favor of the petitioner, despite the order of the learned executive court, the same has not been done.
Whether any report has been called for from the executing court?
Report,
We call,
the Nazir report, my lord.
yes.
Warrant of attachment also, my lord, several
We'll
days.
call for a report from the executing court by the next date after receipt of the report.
Very well, my lord.
Heard Mr. N. Chaudhary, Learned Counsel for the petitioner. None has appeared. None has appeared for the respondent. Who is the respondent?
My lord, the respondent firm has been liquidated. A liquidator has been appointed. The liquidator has merely filed his response before this court. The service has been deemed by an order of the Lawazima. Order date is 7/8/2024 of the Lawazima court.
Though the notice issued to the respondent is deemed to be served by the order dated 7/8/24 of the Lawazima Court. In view of the order of the Lawazima Court, as the notice issued to the respondent is deemed to be served, this revision petition shall proceed ex parte against the respondent. This revision petition has been filed by the petitioner praying for expediting the execution of the arbitral award dated
8/2/1999, my lord.
8/2/1999. The execution case which is pending before the court of the District Judge Golaghat is also of the year
2009.
2009, which has been registered as money execution case number 1/2009. Stop. In view of very old pendency of the execution case, this court deems it proper to call for a report from the executing court, that is the court of learned District Judge Golaghat, stating in detail the reason for delayed for pendency of the said execution case for so long without execution. Let the report be called for before the next date. Let this case be listed again on 30th of October, no, 6th of November, 2020. Let the report come.
Deeply obliged, my lord.
Analogous methods were there, my lord. 18, my lord, LA appeal filed, my lord, in that area. Already some appeal.
Now, what is your submission?
My submission is if these appeals are filed, my lord, for enhancement of the award, my lord. Here, my lord, this happened actually, my lord, some of the similar matters has been already admitted, record called for. And my learned can also, yeah, in some cases.
Not
So-
Mr. H. Das, learned counsel for the appellant. Also at Mr.
CKS Bora for respondent number 1 and 2.
CKS Borwa appearing for respondent number 1 and 2. Anybody appearing for the government? This appeal under section 54 of the Land Acquisition Act 1994 has been filed by the appellant against the judgment dated 21/12/2019. Is it within the period of limitation?
Yes, yes, very well puzzled.
Already delay condom.
Okay. 21/12/2019 passed in LA within bracket reference case number 19/2023 by the Court of Learned District Judge Gwalpara, comma. Full stop. This appeal is admitted. All for the relevant case records. As Mr. CKS Borwa has appeared for respondent number
1 and 2.
1 and 2, no formal notice need to be issued to respondent number 1 and 2.
He is state of Assam.
Please that senior government D. Nath, senior government advocate, his name may be recorded for respondent number 3. D. Nath, senior government advocate, Assam. For respondent number 3.
You have served notice on him.
Yes, already served. Would have had, serving public.
The
Extra copy. had served.
respondent number 3 is represented by Learned Senior Government Advocate D. Nath. His name may be reflected in the cause list as engaged counsel for the respondent number 3. Henceforth, list this appeal again after receipt of the case record from the trial court.
Extra copy to serve.
The
DNAT.
The appellant shall furnish extra copies of memo of appeal to the respondent number 3, learned counsel for respondent number 3. You have received.
So I have already communicated. If you want to say, no harm.
Yes, accordingly.
State council is absent today, so better have extra copy.
after puja vacation of.
Lordship, the conducting counsel, Mr. R. Sharma is not present today, my lord, due to his some personal difficulties, my lord. So let the matter be passed over for the day, my lord. Only a small prayer, my lord. Let this matter be listed tomorrow, my lord, because an execution proceeding is going on, my lord.
Tomorrow we are already
I
full.
totally understand, my lord. I really understand. But
Lordship, only for this case, Lordship, the execution proceeding is held up on, Lordship.
State.
So, yes, not state, but they have been gonna filing petition in respect of
my lord,
pendency of this
the matter
case
is tomorrow fixed
before
in
the executing court.
My lord, so that is the reason, my lord, if this matter may be fixed tomorrow, then my lord, then
Is
their
it-
problem will be solved itself, my lord.
No,
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 but it
That
is fixed today.
Yes, my
You
lord,
are
I
not
totally
ready.
understand, my lord.
Yes,
but
Lord.
The difficulty is on the part of the,
But if use money is involved in this case, so they are just dealing the matter, nothing else.
not dealing, my lord. Today it was an unfortunate, my lord, it was totally an unfortunate. Let it be tomorrow, my lord.
Mr. What is your name?
A day.
A day, learned counsel for the appellant. Also, Mr.
KJ.
K. Jain, learned counsel for respondent number 1. Learned counsel for the appellant submits that due to personal difficulty of the conducting counsel, Mr. R. Sharma, he prays for listing this matter tomorrow. The counsel for the respondent does not opposes the prayer. Let this matter be listed tomorrow, that is on 4th of October 2000.
No, sir.
Okay.
Keep your.
May I please your lordship? My lord, it is a regular first appeal. It may be admitted.
Heard Mr. A. C. Sharma, learned counsel, learned senior counsel for the appellant, assisted by Mr. N. Brahma, learned counsel for the appellant. This appeal has been filed by the appellant impugning the judgment and decree passed by the Court of Learned Civil Justice Senior Division, Kamrup Metro in title suit number 407/2013 on 18/6/2024. The appeal is admitted. Let the case record of title suit number 407/2013 be called for from the trial court. Let the notices be issued to the respondent. The appellant shall take steps for issuance of notice upon the respondent by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable on 12th of November 2020. List accordingly.
I have one IA 3109.
We'll issue notice now.
In the meantime, the execution of the decree may be stayed.
Whether execution case has been filed.
That we have not any information.
So let the notice go.
No, my lord, they may institute they may initiate the execution. While the appeal is admitted, then the execution may still stay.
Heard Mr. A.C. Sharma. Okay, heard Mr. A.C. Sharma, learned counsel for the applicant. assisted by Mr. N. Brahma, learned counsel for the applicant. This application under Order 41 Rule 5 of the Code of Civil Procedure has been filed for stay of execution of the impugned judgment dated 18/6/2024 passed by the Court of Learned Civil Judge number 2, Civil Judge Senior Division number 2, Kamrup Metro, entitled suit number 407/2013. The said judgment and decree has been impugned by the applicant by filing the connected regular first appeal, which has been registered as RFA number 60/2024. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable on, what was the date? Date.
12th November.
12th November. The execution of the impugned judgment on order shall remain stayed till the next returnable date.
Hello.
Yes, what is this?
Lordship, the notice was issued, the other side has appeared, Lordship may take up it for final disposal.
When? When? Today?
Today, I'm ready, Lordship.
I'm also ready, my lord. What happened, my lord, the plaintiff, the respondent, plaintiff filed a suit and injunction was granted. And against that injunction of the defendant, filed an appeal.
Is there any interim?
Yes,
Interim
my
notice
status quo is there.
Lordship, the
We'll admit this and take it up.
My lord, it can be decided, it can be remanded back to the appellate court because appeal is pending. Against the injunction order, they have filed an appeal before the civil judge. And in that misappeal, my lord, they have filed a petition under Order 41 Rule 5 for a stay of the injunction order. And that was rejected. And against that order, my lord, they have filed this revision petition. So already main appeal is pending. So let that status quo be there. And it may be remanded back to the appellate court. It may be finally decided that misappeal, my lord, their misappeal.
Lordship.
Okay. Heard Mr. D. Yes. This is item number?
Item number 12.
12.
Heard Mr. D. Das, learned counsel for the petitioner. Also heard Mr. N. Hawk, learned counsel for the respondent. This application under Article 227 of the Constitution of India has been filed by the applicant, by the petitioner, by the petitioners, impugning the order dated 10/5/2024 passed by learned Court of Learned Civil Judge, Senior Division, Borpeta, in Miss J case number 63/2024, in Miss Appeal number 1/2024, refusing to stay the order dated 29/4/2024, passed by the Court of Learned Civil Judge, Junior Division, number 2, Borpeta, in Misde case number 61/2023, in title suit number 114/2023. The facts relevant for consideration of this revision petition is that who was the plaintiff?
Present opposite party is the plaintiff.
That the respondent number 1,
Sole respondent.
that the respondent herein had filed a suit for partition
I've explained in paragraph 2.
partition as well as for permanent injunction. Partition and permanent injunction.
Also challenging the sale deed of the present petitioner, petition number 1.
And also challenging the sale deed in respect of the. So which land? Schedule,
B2 land.
schedule B
2.
2 land of the plain. Filed by him before the Court of London, Civil Judge Junior Division number 2, Borpeta. The said suit was registered as title suit number 114/2023. In the said suit, the respondent as plaintiff petitioner has also filed an application under Order 39 Rule 1 and 2 read with Section 151 of the Code of Civil Procedure, 1908, seeking an interim and seeking a relief of temporary injunction against the present petitioners who were arraigned as defendants in this said suit from disposing the plaintiff opposite parties. Who is the plaintiff?
Plaintiff is the respondent.
Plaintiff. Within bracket respondent here, stop.
Opposite parties.
Opposite party.
In the said Miss case, what was
Injunction was granted.
Injunction was granted also.
the trial court granted temporary injunction in favor of the
Plaintiff.
Opposite party plaintiff.
opposite party plaintiff. In favor of the plaintiff. Within bracket respondent hearing.
Opposite party.
Stop. Against the. Now, next para, being aggrieved with the said order of temporary injunction, the present petitioner preferred an appeal under Order 43 Rule 1R before the Court of London Civil Judge Senior Division, Borpeta. And the said case was registered as
Miss Appeal 1 of 24.
Miss Appeal 1 of 2024.
And it is already admitted.
So the said appeal is admitted by the Court of London Civil Judge Senior Division, Borpeta, and is pending for disposal before the said court. Stop. Next para. In the aforesaid Miss Appeal 1 of 2024, the present appellant also filed an application under Order 41.
Rule 5.
No,
Rule
Order.
Rule 5. also. At
Order-
page 59. also.
Order 41, Rule 5. For what you have filed?
For by
For
taking
stay of
stay
the
of-
injunction order.
for stay of injunction. You have sought two reliefs. You are appealing against that order.
No, he has filed appeal.
No, the defendant has filed.
Okay, for stay of
Injunction order
the
granted
injunction granted
in favor of the plaintiff.
in favor of the plaintiff by the Court of Learned, Civil Judge Junior Division number 2
Lordship.
in Ms. J case number 61/2023. What happened then?
That is pending.
Stay was not granted.
No, Lordship, by order dated 10/5/24, Lordship, which is at page 64. The stay was not granted, Lordship.
Against that order you have.
Yes, Lordship.
Yes.
The Court of Learned, Civil Judge Senior Division Borpeta by order dated, where is that order?
10/5
Page
2020.
64, Lordship, Annexure 8, 10/5/24.
Order dated 10/5/24. Disposed of the application for stay of the injunction order by rejecting the prayer on the ground that the injunction granted by the trial court was already challenged on. No.
The finding of the court is that at paragraph C, Lordship, the petitioner stated that the injunction order is vague. That what the present petitioner stated before the learned appellate court, Lordship. That's why the prayer was not considered.
Now, why it was rejected?
On consideration, Lordship, if I may read, Lordship, on consideration, it appears that the petitioner appellant has stated at paragraph C of the petition that according to law, said order of temporary injunction without specific mention is itself is vague. In view of such statement and on consideration of the order dated 29/4/2024, this court is of the view that there is no scope of grant of any stay in respect of the order of temporary injunction.
Last line. On the ground manager by rejecting the prayer of the staff on the for the state stop. Against the said order, the present revision petition has been filed by the petitioner who was the plaintiff,
Defendant.
who was the defendant before the trial court.
Yes.
Learned counsel for both the parties have submitted that by order dated by order dated 3/7/2024, this court has directed to maintain status quo in respect of the Schedule B within bracket 2 land as mentioned in the plain. Stop. Now you are agreeing to mention status quo.
Till decided,
Till disposal of the appeal.
As learned counsel for both the parties have agreed, have agreed that as the appeal filed by the defendant under order 43
rule 1.
Order 43 rule 1R is pending before the court of the learned senior division Borpeta. This revision petition may be disposed of by directing the what direction?
Civil judge senior divisions to dispose of that appeal, ma'am, filed by the defendant.
To dispose of the
Miss appeal number one of
miss appeal number 1 of
2020.
2024 expeditiously.
Ma.
Until then, both the parties have agreed to maintain
Some time,
status.
some time frame maybe, we are not
Expeditiously will allow.
within 1 month, my lord,
No, 1 month is unrealistic.
October is a full of holidays. Lordship.
within 2 months,
Within 3 months.
3 months. My lord,
And both the parties have agreed, learned counsel for the both the parties have undertaken that the parties have agreed to maintain status quo till the pendency of the
please, sir.
miss appeal number 1 of 2024 before the court of learned civil
Judge.
justice senior division. This revision petition is accordingly disposed of with the observation. Direction did not make it. With the above observations.
My lord, this status quo order may not influence the, my lord, in passing that, my lord, dispose of that, my lord. appeal.
Yes, the first appellate, the appellate court before which the miss appeal is pending shall not be influenced by in arriving at a decision in the appeal pending before it by this order in any manner. This revision petition is accordingly disposed of.
Statutory appeal lordship,
Heard this by A.J. Sakia, learned counsel for the appellant. Also heard Miss
AG Chaudhary,
A.G. Chaudhary, learned counsel appearing for
respondent number 1. Your Lordship.
respondent number 1.
Yes, your lordship.
Respondent number 1. This appeal under section 173 of the Motor Vehicles Act has been filed by the appellant insurance company, impugning the judgment and award dated 13/7/2023, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro. Kamrup or Kamrup Metro?
Kamrup Metro.
Kamrup Metro, Assam in MAC case number 2535/2017. Stop. These 2 and 3 are struck out.
Lordship, in delay petition lordship, they were struck off lordship.
Since Ms. Chaudhary has appeared for respondent number 1. You are appearing for claimant.
Yes, your lordship.
No formal notice need to be issued to respondent number 1. As regards the remaining respondent, the appellant shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 20th of November 2020. List accordingly.
Your lordship, since the claimant has been suffering since from the last 7 years, so if 50% of the awarded may be released to the claimant,
The petition is there.
Now, what is the prayer?
prayers that if your lordship may please to release 50% of the awarded amount. Your Lordship.
Stay is not yet.
The petition is there. lordship.
Petition. You deposit 50%.
Yes, lordship.
This application heard both parties. Heard Mr. A.J. Soikian and counsel for the applicant and Ms. A. Chaudhary.
Lordship, actually, there are 2 another case, analogous case. They have already paid the amount to these 2 cases. So Your Honor, actually, there is no infirmity in the judgment. Everything is fair, Your Honor, because the claimant has suffered 80% of the permanent disability and he is still in bed. He's in bedridden condition. So if possible, if 80% may be released, it will be helpful for the new lordship.
They are ready to
50% lordship may be released, lordship.
50%.
We will deposit lordship 54 weeks lordship.
This application has been made by the applicant insurance company under Order 41 Rule 5 of the Code of Civil Procedure for stay of execution of the impugned judgment and award dated 13/7/2023. Passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro in MSC case number 2523/2017. The applicant is ready to deposit ready to deposit 50% of the awarded compensation as a condition for stop. The prayer, after considering the submissions made by the learned counsel, as well as after considering the averment made in the application, the prayer is allowed. The execution of impugned judgment and award dated 13/7/2023, passed in MSC case number 2523/2017, is hereby stayed, subject to payment of 50% of the awarded amount, subject to deposit of 50% of the awarded amount by the insurance company to the registry of this court within 4 weeks of the date of this order. Stop. On such deposit being made, the said amount shall be disbursed to the claimant opposite party by the registry after proper verification. This interlocutory application is accordingly disposed of.
Obliged, lordship.
My lord, in this matter, before my learned senior make his submission, I make a submission, my lord, with a prayer. My lord, because today, because of some medical emergency of my father, I was unable to be present in the first term, my lord. And after that, my lord, along with other matter, Mr. Das was also not able to go through the LCR, my lord. Maybe any date, my lord, as my senior guy, on that day, I will complete, my lord.
After vacation.
Any day.
The only thing is that he is behind the bar, my lord.
My lord, I can understand, my lord.
The
Any
only
day.
point lordship decided on the last occasion, my lord. Whether, my lord, it will be a petition under section 397 or 482, my lord.
No, but this is an NDPS matter involving commercial quantity.
My lord.
So we have to.
Regarding, my lord, that washing part, my lord.
Yes, hearing is required. We'll fix a date after vacation. In the first week of November.
November, my lord. Can it be, my lord, immediately after opening, my lord?
I will not be there.
Lordship will not be there.
It is part heard. You choose a date. Heard Mr. B. M. Chaudhary, learned counsel for the petitioner, also heard Mr. K. Bosho, learned additional public prosecutor, who submits that due to some personal difficulty, he could not go through the records of the case and prepare himself, and prays for some time, prays for adjournment on that ground. The prayer is allowed. Let this case be listed again on 7th November. 7th November as part heard matter.
But deeply obliged. May I please your lordship? My lord, the appeal is arising out of the order dated 17/9/2024, my lord. That is at page number 133 to 141, my lord. But before I should take up your lordship to that order, I would like to just narrate something about the history of this case, my lord.
Arbitration link. Yes,
Arbitration.
yes,
37(1)(a), my lord.
okay. Yes, please.
My lord, work order was issued by the Assam University, my lord, on 9/2/2021. And thereafter, my lord, I was asked to supply 6 number of buses out of 20 at the first phase, my lord. And for that purpose, a contract agreement was entered into, my lord, that is at page number 36. I would like to take your lordship to 4 of the clauses of that contract agreement, my lord. It is at page number 36, typed copy. Down below that is the original copy, my lord.
Page number?
Page number 36, my lord, of the memo of appeal.
Yes.
My lord, clause number 1 is, the first party shall provide services of 6 numbers buses at first phase for ferrying the student and the staff of the second party on the following routes. Routes are, my lord, Silchar town to Assam University Silchar campus, 5 bus, and Hailakandi, Assam University Silchar campus, 1 bus. Now, the rate was fixed, my lord, to the tune of rupees 81,999 per month for each bus. Now, my lord, after that, I would like to take your lordship to clause number 26. At page number 40, my lord.
Yes. Yes.
The period of contract, my lord, is mentioned in clause number 26 that the contract period will be initially for 3 years, which includes university vacation period of 2 months annually, for which only idle charges shall be paid, which may be extended for 2 years, subject to requirement and satisfactory performance and mutual consent of both the parties. Now, my lord, as per this clause, initially the contract was for a period of 3 years, but it was subject to extension. And the extension has a ground, my lord, that I will take your lordship to that. Now, thereafter, my lord, clause number 29.
Yes.
In case of any dispute, that any dispute arising out of any aspect of this tender shall be settled through mutual consultation by the parties under Arbitration and Conciliation Act 1996, and as amended from time to time, it shall be settled through sole arbitrator appointed by the Assam University. The award of the arbitration shall be final, conclusive, and binding upon both the parties. Now, my lord, when my 3 years period was about to be expired, then I made a request to the university authority, and that was extended, my lord. If I can take your lordship to page number 48. Page number 48, my lord. It was extended by this letter of the university for a period of 6 months only. Page number 48, my lord. May I read that part, my lord?
48, 6 months.
6 months, yes.
Okay.
So with reference to the subject cited above, I am to inform you that the competent authority of the university has decided to extend the agreement of the above mentioned contract for a period of 6 months with effect from 10/4/2024 with the existing rate, terms and conditions of contract. You are required to execute a deed of agreement for the extended period on non-judicial stamp paper of ₹100 within 10 days. You are further requested to give your acceptance within 3 days from the date of issue of this letter. So, my lord, by this, from 10/4/2024, extended for 6 months, it will end on 9/10/2024, my lord. In this month itself, on 9th of, when the vacation will start, my lord.
with this one. Now, my lord, after that, I made another request to them that as we have already entered into extension period of 6 months, let it be completed by further 18 months, which is already agreed in clause number 26, my lord. Clause number 26 speaks about
3 years plus 2 years.
3 years plus 2 years, my lord.
Okay.
Yes. My lord, that my letter is at page number 79. But when that was not done, then I opted for, my lord, arbitration clause as per clause number 29. Page number 79 is the
You
request for.
prayed for further extension of 18 months,
Yes, my lord.
which was rejected.
That was not adhered to.
Okay.
Yes. That is, my lord, page 78. Page 78. In inviting reference to the letter on the above subject, it is to inform you that your request for extension of agreement period for hiring of buses is considered for extension of 6 months only, as intimated to you by this office letter, event number 4/6/2024. Fresh tender shall be floated in the government e-port, in the GOV e-portal very soon. You may participate in the tender process if interested. So practically, my lord, by this letter, that my request was turned down. Now, my lord, thereafter, I opted for clause number 29, and that is for arbitration. And this is at page number 79, my lord. This is a long letter highlighting each and everything, my lord. I asked for resorting to the arbitration, my lord. Now, my lord, to this my letter, at page number 131, there was an appointment, page number 131, my lord. They have shown to have appointed one arbitrator, my lord.
Okay.
Page number 131. I would like to read before your lordship this appointment.
Yes.
This is to inform you that as per your letter dated 27/2024, the Assam University is pleased to appoint Shri Palash Das, MBA LLB, advocate of the District Bar Association Silchar, as sole arbitrator under Arbitration and Conciliation Act 1996 to adjudicate the matter. Take note that both the parties shall be entitled to raise preliminary objections before the learned arbitrator, which shall be decided by the learned arbitrator in consonance with law. The learned sole arbitrator shall proceed with the arbitration proceeding as per Arbitration and Conciliation Act 1996. The learned sole arbitrator shall be entitled to a fee in accordance with the fourth schedule to the Arbitration and Conciliation Act 1996. Both the parties shall share the fee of the learned sole arbitrator and arbitral cost equally. All rights and conditions of the parties in relation to the claims are kept open to be decided by the learned sole arbitrator on their merits in accordance with law. You are requested to give your consent for the same to determine the dispute arising between the parties to the agreement within a period of 1 week from the receipt of this letter. My lord, this is the letter dated 12/8/2024. Immediately, we reacted to that this person cannot be appointed an arbitrator. And that my letter is, my lord, at page number 132. Your letter intimating the appointment of Shri Palash Das, advocate, as arbitrator. Preliminary objection against the appointment of arbitrator. My lord, I have already stated in the paragraphs, with reference to the subject cited above, I would like to convey that in accordance with the arbitration clause in agreement, myself through my advocate caused service of notice for appointment of arbitrator in accordance with the provisions of Section 11 of the Arbitration and Conciliation Act 1996. In response thereto, by the letter under reference, we have intimated about the appointment of Shri Palash Das as arbitrator. We have inquired in the bench in Silchar, and therefrom we have gathered that they are retired district judges from the panel of arbitrator created by the Honorable Guwahati High Court,
Apart from that, there are seniors advocates, including designated seniors in the District Bar Association, Silchar. It is therefore desirable that a retired district judge from the panel of the Guwahati High Court or a senior advocate having experience in litigation, conversant with the procedures of law, the appointment as sole arbitrator. I raise my preliminary objections, citing reasons for the same, with the hope that such reasonable objection is heard. Thereafter, my lord, when it was not acted upon, then I filed an application under Section 9 of the Arbitration and Conciliation Act. And the order which is passed, my lord, Section 9. May I read, my lord, Section 9 first?
Yes. The arbitrator was appointed.
Arbitrator was appointed. We are not agreeable to, because he is not a person either from the panel of arbitrators appointed by the Honorable Guwahati High Court, or he is not a senior advocate of that bar who is conversant with the law.
Okay. Read
Yes.
9. Yes, please read 9.
My lord, I am placing before your lordship that Section 9. Entry measures, etc. by court. A party may before or during arbitral proceedings or at any time after the making of the arbitral award, but before it is enforced in accordance with Section 36, apply to a court. My lord, here the words are, a party may before or during arbitral proceeding. Before or during arbitral proceeding. Arbitral proceeding, my lord, as of date has not started. But before that, we have made the application under Section 9 before the learned court below for the appointment of a guardian for a minor that is not required, my lord, for an interim measure of protection in respect of any of the following matters, namely, the preservation, interim custody or sale of any goods which are the subject matter of the arbitration agreement, securing the amount in dispute in the arbitration, the detention, preservation or inspection of any property or thing which is the subject matter of the dispute in arbitration or as to which any question may arise therein, and authorizing for any of the aforesaid purposes any person to enter upon any land or building in the possession of any party, or authorizing any samples to be taken or any observation to be made or experiment to be tried, which may be necessary or expedient for the purpose of obtaining full information or evidence. Interim injunction or the appointment of a receiver. Such other interim measures of protection, my lord, D is attracted. Such other interim measure of protection as may appear to the court to be just and convenient. And the court shall have the same power for making orders as it has for the purpose of and in relation to any proceeding before it. Where before the commencement of the arbitral proceeding, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceeding shall be commenced within a period of 90 days from the date of such order or within such further time as the court may determine. Once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under Section 17 efficacious. So this, my lord, was heard, by application was heard. It was registered as Miss J case number 11, my lord, of 2024. And the order is, impugn order is, my lord, at page number 136, 134, my lord. 134, it starts from 134. My lord, I would like to show the perversity in the order. And in the first part, my lord, though it is a long order, but I would like to read some portion of that order, my lord, because section clause number 26 is also resorted to. The case of the applicant in nutshell is that there was an arbitration. My lord, whether your lordship has got it. 134, my lord.
130.
Yes, my lord, 134.
Yes.
133, it starts from 133, my lord. 133. Both the sides are represented. I have heard the learned counsels appearing for both the sides on the point of jurisdiction of this of this court, learned counsel for the applicant has submitted photocopy of notification number so and so dated this book, the 13th February 2019. Perusal of the said notification discloses that on the recommendation of the Honorable Guwahati High Court, the Governor of Assam is pleased to designate the courts of all civil judges, senior division as commercial courts, and courts of district judges in all the districts of Assam as appellate court at the district level under the commercial courts, commercial division and commercial appellate division of the High Courts Amendment Ordinance 2018. Therefore, in view of the aforesaid notification, this court is satisfied with the issue involved as regards the jurisdiction of the court, and accordingly, this court finds that this court, being civil judges senior division, has jurisdiction to try this case. Now, this instant misarbitration case has arisen out of a petition, white petition number 54 of 4 or 24, filed by the representative of the applicant under Section 9 of the Arbitration and Conciliation Act 1996, seeking a temporary and mandatory injunction against the respondent. The case of the applicant in nutshell is that there was an arbitration clause in the agreement between the applicant and the respondent, and by the said agreement, the petitioner was assured 5 years of contract. However, after successful completion of 3 years of the contract, the respondent unilaterally decided to float a new tender, violating the terms of another 2 years. As per the applicant, the buses have been purchased on hire purchase, and the landed property of the applicant and her husband has been rendered as collateral security. And if the period is not extended by 2 years, the applicant will be unable to repay the loan amount, and resultantly, the bank will not only repurchase the buses, but also will proceed with the process for taking over possession and sale of immovable property. That the extension of the period of contract by 2 years is not only legitimate expectation for the applicant, but also contractual obligation of the respondent under the work order of the agreement. The applicant has thus prayed for restraining the respondents by an order of injunction till appointment of the arbitrator from any way floating any tender with regard to hiring of buses to take students to the university, and from including any other contractor for providing buses to carry students to the university, hence the prayer. The respondent side has filed written objection against the said application of the applicant, denying almost all the averments of the applicant. It is stated that the present application is a frivolous one, and the same has no cause of action, and the same is not maintainable. I am thereafter, my lord, I have marked it, and I am reading those lines on the basis of which that petition was rather rejected. My lord,
Which
as yes, here itself, my lord, as per the answering respondent, period of contract was for 3 years, which may be extended for 2 years, subject to requirement. Satisfactory period of contract was also mentioned in the said work order. That after completion of the said contract period, the university had asked the applicant to provide car and cabs at lower rate, as her rate are much higher than the prevailing market rate. My lord, here I would like to submit before your lordship that my contract, which was entered into, was for 3 years for 6 number of buses, and extension for 2 years again for those 6 number of buses. Nothing more than that. But here the learned, the counsel of the opposite party, in the objection, has categorically written that after completion of the said contract period, the university had asked the applicant to provide car and cabs at lower rate, as her rates are much higher than the prevailing market rate, but the petitioner refuses to lower her rate. Hence, the university had floated fresh tender for acquiring of Toyota Innova car, which is a premium segment SUV at a cost of 75,000. My lord, I am no way concerned with that. Yet the learned trial court has taken the view on the objections being raised by the respondent, and my lord, that my petition is rejected. Now thereafter, my lord, lesser comparison to the charges made by the petitioner. It is stated that as no mutual consent was made, and hence the contract period was not renewed for the further period of 2 years, but the university authority has extended for contract period for 6 months, considering the prayer of the petitioner or the applicant. As per the answering respondent, The university always follows the norms and regulations issued by UGC and government from time to time, and there is no willful disparity on behalf of the answering respondents while not extending the term period of contract. As such, the answering respondent has prayed for dismissing the case. During course of hearing, learned counsel appearing for the applicant drawing attention of this court to the clause number 26 of the agreement entered into by both the sides has submitted that the petitioner has a strong prima facie case in their favor, and so also the balance of convenience and inconvenience. And in the event of refusal of the injunction as prayed for, the applicant will suffer irreparable loss and injury.
What relief you sought before the,
Before this, my lord, my appeal is required to be admitted.
no, before the district judge's court, the civil judge's court,
Yes, not to float
tender.
during the period of extension, not to float any tender, my lord. And to issue work order for remaining 18 months, my lord. Because that was within the contract period. And my lord, I have invested lot of money because of the reason that they required new buses. I have taken loan from the bank. I have invested that much amount. And if by that contract is cancelled, my lord, where I will fly the buses? And it is, had it been not within the norms of the contract, my lord, I would never mind, even if my petition is rejected. But my lord, it was within the norms, 3 years plus 2 years. And within that 2 years, my lord, 6 months was already extended. My lord, so far the three characteristic features which they have mentioned, my lord, subject to requirement. My lord, so long the university is there, flying of the buses will be there. So there is subject of requirement. And satisfactory performance. My lord, within that period of 3 years and within the extended period of 6 months, there is no objection as of date raised. And that has not been highlighted by the opposite party in the application filed by me under section 9 of the Arbitration and Conciliation Act. Had there been any allegation upon me, my lord, then also the question would have been different. And so far the mutual consent is concerned, my lord, mutual consent cannot be over there because he is asking about the Toyota, which is only 8-seater. I was not in the contract for supplying of the Toyota, my lord. The learned trial court has totally perversely rather entered into this part of the matter, my lord. Because the objection was for Toyota. I am not the part of the Toyota. I am for the buses only, my lord. So my respectful submission before your lordship, which time is also running fast. My submission before your lordship is, my lord, yes, that my appeal is required to be admitted. And the order which is I have made in this 3141, my lord, only one paragraph, my lord, is required to be entertained by your lordship. At page number 17, my plea.
What relief you are seeking? here?
Yes, my lord. Extension of those 18 months. And for that purpose, there should not be any floating of the tender.
It's required to
Because-
be-
My lord, because there is no allegation against me. I am as clear as a white shirt.
You have a,
Yes. Or my learned friend will say, my lord, before your lordship, or submit before your lordship, that the tender has already been floated. So even if the tender is already floated, my lord, it should not be, work order should not be issued for 18 months, my lord, to any other entrepreneur.
you have also participated.
No, my lord. No, I am not participating.
You will reply.
Yes, Lord, definitely.
We will take this item as first item tomorrow.
My lord, tomorrow, my lord, I am having a difficulty because today night itself, myself and one of the colleagues will be moving outside. That's why he had mentioned before the lordship that this matter is so urgent. And your lordship had on that very day allowed only this matter only by order.
Since my learned senior has already completed his argument, Lordship, I will address tomorrow at 10:30. Other councillors are there.
Because I have lot of work in my job.
Yes, my lord, I can understand that.
We'll
But my lord,
continue.
kindly protect me because I am having a genuine case before your lordship, total genuine case,
Somebody will represent petitioner tomorrow also.
my lord. Mr. Pon Kalida will be there. But today's argument, my lord, from the side of the petitioner, is conclusive in that way, my lord. My lord, it may say that there is a writ petition, but we have not filed any writ petition, my lord. And that's why, just as my learned friend has indicated, we have already got a copy of that writ petition, where I am the order of that writ petition wherein I am not a party. I can just submit before your lordship.
The petition filed by whom?
It is filed by my lord Kishore Kumar Bhattacharya and two others.
Challenging
those-
that same tender.
Yes, Lord.
Yes. For a stay of the tender. That's tender. Fresh tender.
What has happened there?
Lordship, no interim order was granted. I was there.
Maybe.
Yes.
And my lord, those two others are Sumitra Shankar Datta and Neetu Chaudhary. Myself, my lord Meera Chakravarti.
If the petitioner is so apprehensive, before I start my argument, they have adopted my argument also.
No. We have not adopted your argument.
No.
The other persons.
Definitely, Lordship,
Yes.
I have not just opened my argument. They have come with the orders and because while we're sitting in the backside, I just narrated my learned friend that these things happen. And they're taking advantage of that, they are placing this order. I have no objection, Lordship. I'll submit tomorrow also.
No, just a minute, before you leave. That. Where is that clause of extension?
Clause number? Clause of extension. Clause of extension is my lord. Yes, clause number 26 at page number 36 is the start, my lord. And clause number 26 exactly your lordship will find at page number 40. Page number 40, my lord.
It says the contract period will be initially for 3 years, which includes university vacation period 2 months. For which the only charge, which may be extended for another 2 years, which may be extended for.
Yes.
Now this has to be interpreted, which may be extended,
Which may be extended.
Which may be extended.
which may not be extended.
Yes, but may be extended subject to satisfactory performance and requirements and mutual consent. Conditions, that's why.
Yes.
These were the 3 conditions, my lord. Subject to requirement, my lord, in the same clause, your lordship will be find in the last 2 lines. Subject to requirement and satisfactory performance and mutual consent.
Do you want to say that if there is satisfactory performance, then it has to be
Extended.
extended?
Yes, ma'am. Yes, ma'am.
If there is no unsatisfactory performance,
Then
then
I
it-
don't have any, no, I have no right.
Okay.
I have no right. But that, my lord, within the tenure of those 3 years, and that within the tenure of extended period of 6 months, satisfactory requirement ought to have been objected by that I have ever faulted to. But that has not been done.
for not extending the,
Yes,
for not extending the contract.
yes, my lord.
Okay. Heard Mr. A. Sattar, learned counsel for the appellant. I'll admit tomorrow.
Congratulations.
Heard also Mr. SCKL, learned
Standing Council Assam University.
Standing Council, Assam University. The hearing remained inconclusive. Let this matter be listed again as part heard item in motion column tomorrow, that is 4th of October, as the first item.
Lots.
Congratulations. Congratulations.
My junior has found permission was granted. This matter is in connection with item number 57. So my lord, it is not possible for today. So may I pray that, my lord, these 2 matter may be listed on 15th of, my lord,
vacation code, 50 lakhs.
Lordship, vacation will be out. Actually, there is the item.
All of
There
you
is no
may,
urgency. There is no urgency. Only necessary.
all of you may take up the matter tomorrow.
No, tomorrow we are already
Pilot.
full.
Already
So
their
it-
revision has been instructed to us.
That's why we have filed. It's not,
my
not for you to say, it's in fact.
After on the reopening day, we may fix it. On the date of reopening.
Reopening day.
Instead of 15, it can be on 21st.
My lord, as you lost, but matter is, on our point of view, it is urgent.
Item number
Item number 56, 57,
6,
57.
57. Item number 57 on request of Mr. A.K. Purkastha.
Along with the unlisted matter.
Which unlisted?
My lord, 408.
No, let me first.
Because
talk.
permission was granted not to move the
Also
petition
heard
today.
Mr. B.K. Bhagawati. On request of learned counsel for both the sides, let this matter be listed on 21st of October 2024. Which is the unlisted
Unless,
matter?
my lord, I have CRP number 408 of 2024.
I send it. Here also councils are same.
They are, my lord, I don't know, my lord, they didn't file in that.
We are not. We are not.
On request of learned counsel for the applicant, let this matter be listed along with CRP IO number 222/2024 on 21st of October 2020.
Lordship. Lordship, item number 48 and 49, Lordship. I pray that this matter be listed on the 22nd, Lordship. No, 22nd, 24th, I am in function.
Third, Miss. You're for?
I'm for the respondent, Lordship.
Third, Miss S. Parveen. Learned counsel for respondent. Who is for the appellant?
Mr. D. Saikia, senior advocate was there, and Mr. Diganta Dasi Junior is here.
Mr. R. Pujari appears for respondent number, for the appellant. For the appellant. On request of learned counsel for both the sides. Let this matter be listed on 22nd October.
I also have a prayer, Lordship. Lordship has seen this matter doesn't reach. It needs urgent disposal, Lordship. Let it be on as a top of the list, Lordship.
On that day, you may mention before the court.
Lordship.
A victim mentioned item number 54, madam. Motion method, madam, as my senior was busy in the court, madam, it cannot be taken up. I took time for time being, madam. But can it be taken up tomorrow, madam? We have some urgency in this case. Motion method. Item 54.
On request from Mr. I.H. Saikia, learned counsel for the petitioner, let this matter be listed on 4th of October.
Item number 23, order 41 rule 11 hearing,
After vacation.
can it be some date fixed because execution case is pending, that is why some urgency is there.
Third, Mr. N.K. Kolita, learned counsel for the applicant. This matter could not be taken up for hearing today. Let this matter be listed. Again, on when do you want?
21st, madam.
On 21st of October 2000.
Lordship, item 46, your Lordship may prefer a fixed date, your Lordship, after vacation. Item 46.
What is 46?
RFA, and for the respondent.
I am from the appellant, Lordship. It is the after Puja vacation.
Date may kindly
No,
fix,
no,
your
no
Lordship.
fixing.
After vacation, a date may kindly.
Registry will fix the date.
Maybe on
the-
28
heard-
or 29
no,
October.
no.
it was
Heard Mr.
A.R. Karim for
A.R. Karim,
the respondent.
Learned Counsel for the respondent. Also heard Mr.
P. Chakraborty.
P. Chakraborty, reverse for the order. Learned Counsel for the applicant. This matter could not be taken up for hearing. Let this matter be listed after puja vacation on a date to be fixed by registry.
I think prefer a fixed date, Lordship, 20
No,
or
like-
29.
No, yes, anybody else?
Item supplementary item 60, Lordship. Matter was listed for order 41 higher. So opposite party has already filed execution proceeding. That matter is very urgent. Kindly
60?
60, supply 60. Kindly matter may be taken up tomorrow, Lordship.
No. no.
Execution is pending. It's very urgent.
Mhm.
So by order matter was listed. It will take only 5 to 10 minutes, Lordship. Apparent perversity is there.
Item 60.
Supply 60. Order 41 here. RSA 188 of 2024. Kindly tomorrow.
I heard Mr. R. of the Learned Counsel for the appellant. Let this matter be listed. This matter could not be taken up today due to paucity of time. Let it be listed tomorrow, that is on 4th of October 2020.
Please, election. Item number 20, election. Maybe it's after vacation, election, any days.
Item number 20. Heard Mr.
PLSK on behalf of BK Kaur.
B. Ali, appearing on behalf of Mr. D. K. Kaur. Let this matter be listed after puja vacation on a date to be fixed by registry.